One is interview protection to the petitioner, and second, my lord, both from the investigating officer asking him to go that whether he has joined the investigation or not.
Who is for the petition?
This is the report, my lord. Conducting counsel is on his legs in court number 1, lordship.
Video. George के लेखा.
Where is this person, petitioner, presently?
Right now out of the country, lordship.
Out of the country.
Out of the?
Country, lordship. And then
Nepal.
lordship is terribly sick, lordship.
Both of them are sick.
Not well, lordship.
When this order was passed, you considered to this order that he will be joining the investigation. Now, why he has not come? When was the order passed? On 24th.
Monday.
Then
Bedridden, lordship.
Both of them bedridden.
two petitioners are there. What about the other? Who is bedridden?
And it is now, my lord, this foreign from the petitioners advocate that they are in a foreign country. Once my lord
Dismiss this application.
Oh, yes, sir. It's for anticipating. Granted by your lordship, they will never come.
No, lordship, they will cooperate with the investigating officer, lordship.
But this is what
Yeah.
how they are cooperating, my lord, has been pleased to see. I can understand one not well, both of them not well, both of them bedridden at the same point of time. And that too in a foreign country.
And lordship, they were in Nepal, but presently they are in Canada, lordship.
Now, see, my lord kindly appreciates this.
And they went there for their treatment, lordship.
In Canada.
Who is ill?
Lordship,
And possibly, my lord, on the basis of my money and possibly basis of some other money taken from other people, my lord. A person who is not able to pay 24 lakhs for the flat can go to Canada for treatment, my lord. My lord will kindly appreciate this point.
Lordship, kindly, lordship, one day acknowledge, lordship, and conducting counsel is court number 1, lordship.
My lord, kindly keep saying-
Pass him a lordship.
Kindly keep saying-
Lordship, then kindly keep this matter.
Otherwise, I will recall this order
Lordship, kindly keep this
because
matter.
you are not joining the investigation. So there is, you have flouted the order of the court, it has to be dismissed then.
Lordship, kindly
Or
keep
else you
this
join
matter.
investigation.
Lordship.
One of the persons could have joined investigation, other could have produced the medical documents. What is the bona fide of the petitioners?
Lordship, kindly
On the
keep
day the order was passed, it was not indicated that whereabouts of your client, whether he is in Kathmandu or Kannada. Now you, when the order is passed, you say that he is in Kannada.
Lordship, kindly.
If they are in Canada, on what basis, my lord, the person who has affirmed the affidavit has affirmed? How has he been authorized, my lord? From Canada, my lord knows that if a power of attorney has to come, it has to come through the embassy. But on the last occasion, I saw from my learned friend's petition, my lord, that some Rijavasi or somebody has affirmed. On the basis of what document, my lord? It has not been.
They were in Nepal, but presently for treatment they are
Okay.
in investigation, lordship. Kindly
So
keep
pass
this
over,
matter.
Raghu.
6 PM, lordship.
Not 2 p.m. He is in court room number 1,
Yes, lordship.
11:15, after half an hour.
Right now, yes.
There's an appeal, my lord, to this going on.
After half an hour.
I can quote.
My lord, item number 4, my lord. I am for the petitioner, my lord, appearing online. Am I audible, my lord?
Yes,
My lord, am I audible?
yes.
Very well, my lord. The corresponding IPC sections would have been 406, 420, and 120B of the Indian Penal Code. Now, my lord, this present petitioner was very closely associated with the family members of the de facto complainant, my lord. He is a broker. He had earlier facilitated the purchase of a flat by the de facto complainant. Now, the instant case is that while the de facto complainant was looking for purchasing another flat, through the present petitioner, my lord, he was introduced to one Nirmal Chand, who had impersonated himself to be the lawful owner of the proposed flat to be sold. An agreement was drawn up and a sum of rupees 60 lakhs was transferred by RTGS to the account of the said Nirmal Chand. Subsequently, my lord, it was found that he is not the legitimate owner. Hence, he neither handed over the flat nor returned the money. Hence, the FIR has been drawn up, my lord, and I have been shown as a conspirator to the entire offense. Now, my lord would kindly come to page 22. Nirmal Chand, in whose account the entire sum of 60 lakhs was transferred, he surrendered and immediately got interim bail. Page 23 onwards, my lord, are my bank statements, my lord. Not a single penny has ever been credited to my account.
Where is
Now,
the
my lord,
bail order?
my lord,
Where is the bail order?
page 22 by the Sessions Court, my lord, order dated 23rd of June 2025.
Yes.
Now, 420, 406 is there, my lord. My instructions are that I have not been served with a notice under 41 capital A at my proper residence, my lord. If served, I am more than willing to comply with the investigation. I don't have anything to hide, my lord.
Okay. Yes.
The statement of the complainant son is that it and
Okay. Which was
Kumar Suman. I don't know what that's accused and this the portable chicken manner. Then see 24.
No, the amount of 17 lakhs, 79 lakhs and transferred to which account?
It was transferred to my bank from details of the
No, whose account? Nirmal Chand?
I don't know.
So
It is
Nirmal
that the KSW jeweler,
Huh.
a GST invoice was received by Suraj Kumar Suman. But it is at page number 159. I don't know. It is that the criminal conspiracy is on behalf of this executive matter.
ঠিক আছে কেউ এলে ফোন করবো
120.
159, my lord. GST invoice of UPS jeweler in the name of, because that is the only evidence which the police has collected against it, my lord. Because the charge is there to be filed. And other bank details are, which was
159 is a
Nirmal Chand.
BPS Jewelers.
Yes, BPS jewelers, which was received by Suraj Kumar.
So what is this document?
That is the GST.
My lord would kindly see in whose name it is.
The allegation, in worship, the amount is yet to be recovered. That is the fact of the case. And since the other person has been granted bail, worship, the no amount was worship recovered from this person. This is he's the only person worship the amount can be recovered. Because he was one of the principal worship conspirators in this case. Bank transactions are from page number 57 to 73. Bank
But then
details of-
Nirmal has been granted bail.
All has been
Yes.
granted, but amount has been recovered from him also.
But then he says that amount of 79 lakhs odd, if it has been transferred, it has been transferred to the account of Suraj. To the Nirmal. It is correct. So he was a middleman.
Yes.
Yes.
The two persons in conspiracy with each other have caused a wrongful loss of rupees 79,70,000, which is not at all a small amount, my lord. And the second thing is that, my lord, the defector in this case is a doctor. And my lord, he was intending to buy a flat for his son, and therefore he approached one Suraj Suman, and this Suraj Suman, who is a petitioner in this case, he introduced him to Nirmal Chand. And they both in conspiracy with each other have defrauded this the de facto. This Suraj Suman, who is a petitioner in this case, he have misrepresented this Nirmal Chand to be the owner of the flat, my lord.
Mm.
And in this way, they have taken an amount of rupees 79 lakhs 50,000. My lord, the case is at the investigation stage, my lord. And my lord, it is very much important to trace out the flow of funds, my lord, where this 79 lakhs 50,000 have been gone, and who are the other co-conspirators in this. Giving bail at this stage, my lord, it will only, my lord, propagate the similar fraudulent practices, my lord, and my lord, the police is required to investigate and establish the links, the call records, and my lord, it is at the investigation. My lord.
He approached the Sessions Court for anticipatory bail.
That is not.
Yes,
an- I think he has. That's all.
Mr. Bhattacharya,
My lord.
did your client file any application for anticipatory bail before the Sessions Judge?
Yes, my lord. That was turned down. Annexed P1, I have annexed it with my application, my lord. Page 9 of my application, 14th July 2025.
Nirmal Chand was granted bail on June.
Yes, my lord. 23rd of June. But apparently solely because he has complied with 41A. But my lord, my instructions as this, my lord, at my proper address in Bihar, it was never served. So if supplied to me, my lord, I will also comply, my lord. I don't have anything to hide.
Let me allocate for the petitioner submits that the petitioner is a broker and acted as a middleman in transfer of a flat for facilitating the transfer of a flat
One.
to the complainant belonging to the co-accused Nirmal Chand. Nirmal Chand, no?
Yes, my
Nirmal
lord.
Chand. Nirmal Chand. However, incidentally, it was found that the said flat, the Nirmal Chand is not the owner of the said flat. The allegations are precisely against Nirmal Chand, who has already been granted interim bail by the learned sessions judge. The consideration price of the alleged flat has been transferred through RTGS the to Nirmal Chand. No such amount has been transferred to the account of the present petitioner. But in the rential complaint, they said that through RTGS, 60 lakhs of rupees has been transferred to your account.
Matlab to an account, and the account belonged to Nirmal Chand, not to me.
What is the in the case diary?
There is also a bank account details of PH Jewelers in Panchayat Patar.
Has any amount been transferred to the account of Suraj?
No, that is not Suraj account. That is because the conspiracy is there.
But my lord, Suraj could transfer in this account.
Yes.
There is a big, there is a state-rooted conspiracy.
You know?
No such amount has been transferred to the account of the petitioner.
Further, the notice under section 35(3) of the BNSS
Right.
have not been served on the proper residential address of the petitioner.
Yes.
However, the petitioner is willing to cooperate in investigation. He seeks for grant of anticipatory bail in favor of the petitioner.
Right.
Opposing such prayer for bail, an advocate for the state submits that the petitioner acted as a middleman and conspired for deceiving the complainant from parting with the consideration amount. The materials collected during investigation would show that the alleged flat did not belong to Nirmal Chand. Therefore, custodial interrogation of the petitioner is very much necessary. He seeks for dismissal of the application for grant of anticipatory bail. Learned advocate for the de facto complainant also opposes the prayer for grant of anticipatory bail on the ground that the petitioner conspired with the co-accused to allure the complainant to part with a sum of rupees 79 lakhs. He also seeks for dismissal of the bail. Peruse the case and materials on record. It is not in dispute that this petitioner was acted as a middleman for the alleged transfer of a flat to the complainant. Belonging to one Nirmal Chand.
And also the flat.
Belonging to Nirmal Chand, which has been misrepresented. Admittedly, no amount has been transferred to the account of this petitioner. Learned advocate for the state indicates that the entire sum has been transferred to the account of Nirmal Chand. The records reveal that Nirmal Chand, co-accused, has been enlarged on interim bail. In view of the above, I am inclined to extend the benefit of anticipatory bail in favor of the petitioner. To meet the investigating officer, Jag Thake for 38. Meet the investigating officer once in a fortnight until further orders. Will join
Very well.
investigation, cooperate with the investigation.
Very
And
well.
attend the court on each and every date fixed for appearance and hearing.
Well.
Allowed.
I'm deeply obliged, my lord. Deeply.
Title number 5.
I will select the study soon. The current one. This is to my one.
पास हो मुझे तो फोटो में वन पोजीशन है
Item number 6. Service upon the victims and not.
my lord
My lord.
sir advocate for the petition
Then I.
Well, for the defect account, I have been appointed
oh
by the
yeah,
legal-
Mr. What is your name?
Mr. Bhomik has been appointed by the legal service.
There you are also there in the yesterday's matter which he corrected the opposite petition number 6.
Yes.
There is also mistake in petition number 4, 5. Durga Roy has been son of Ramapada. It should be daughter of. I have granted you liberty. You correct the details of. ওটা কোথায় গেল ফাইলটা? ভুলে ভরা একেবারে।
One correct, daughter of. Son of.
এটা আছে। এটা পড়ার আগে এটা দেখ লোকজন আসছে চলে যাচ্ছে ভুলভাল। Durga Roy. Durga Roy is the daughter of Ramapada. You find out? কয়টা ভুল ছিল? 5টাও ভুল আছে।
ঠিকই আছে son and daughter of. Durga, this name is used for the male and female both. That's
Ekadashi also. Ekadashi.
Ekadashi is
No, you write it besides that. The liberty granted you have written.
Yes,
Then make it 5 and 6. হ্যাঁ নিয়ে ওটাকে চেম্বারে দিয়ে দিন yes
Allegation is under section 329 surplus 4, 351 surplus 2 of the BNS and 8 and 12 of the POCSO Act. My lord, the allegation is that the victim while returning at midnight from his nearby marriage ceremony and entered her house at the time she was allowed, at the time the present accused petitioner entered her house and robbed her and tried to molest her. This is the allegation. But my lord, the contention is that the true fact is that on such marriage ceremony, one quarrel took place between the family members of the victim and the family members of the complainant. On such reference, they used to make this false allegation against her minor daughter. One more thing, the incident happened as per the FIR on 11/5/2025, and they filed the FIR on after 2 days. This period, and moreover, the present petitioner age is 21 years and victim age is 17 years. That's it, kindly, I will cooperate with the investigation. That's it. It is section 8 and 12.
yes what is the 164 statement
Yes,
service report filed by the state is taken on record. You are for the complainant.
yes, my lord. I have been appointed by the legal aid service.
Service report or your service None appears on behalf of the petitioner. Nor any accommodation is sought for. On the last occasion, that is 25th November 2025, as well, the petitioner was not represented. In view of the above, this CRMA, sorry, the application being number CRMA 772 of 2025 stands dismissed for non-prosecution. Who is for the state in item number 7? Give the name. Dismissed for non-prosecution.
That's not allocated. I think we have not yet been served.
Oh,
That is why
ঠিক আছে।
we are not allocated.
None appears on behalf of the petitioner. এই এটা কি হলো?
ওটা খবর দিয়েছিল বললাম বললাম
তুমি বুঝতে পারবে যে তুই যদি ওখানে এন্ট্রি করো
এটা আইটেম 8
হয়ে যাবে? দেখো তো
খবর দিয়েছিল
এটা আছে কিনা এইটে?
item 8 I am from the state university holding the city.
None appears on behalf of the petitioner. On the last occasion, that is 25th November, nor any accommodation sought for. The full stop দিয়ে করবে না, continuation হচ্ছে।
মানে ফুল
Nor any accommodation sought for. 25. Or as well, the petitioner was failed to appear, petitioner failed to appear. In view of the above, the application being CRMA 775 or 2025 stands dismissed for non-prosecution.
Item 9 I'm grateful.
Service?
I'm for the petition, the state, my lord.
Illul Sahabudda.
Shammi deputy.
Service has been affected. আসেনি হিল্লোল ছিল লাস্ট উইক। Passed over. Hillol Poddar has come today. It pass over.
The morning is happy, was dismissed. I think you might be a little bit.
I think
For a second, I was on the stage.
কি করবে? এও তো হিল্লোল। এটাকে পাস ওভার রাখুন আসুক। Service has been affected.
Item 11
Postmortem report has not been collected as yet. Postmortem report? You have received?
report sent by the IL.
No, PM report has been received.
I mean, they unable to collect. They inform the concerned hospital. Last page, your worship.
The report filed by the state is taken on record. The
If your lordship kindly have a look
report
at the
filed
last
by
page.
report filed by SI NJPPS SPC dated 27 November 2025 is taken on record. Next para, it is found from the aforesaid report that the post-mortem report is not yet ready.
And that was reported by mail by the concerned hospital. Last page.
For such reason, the same could not be produced. In view of the above, The matter is adjourned. Please this matter before the next available circuit bench.
I'm grateful to your lordship.
Next. No. Let them come. You are for?
I'm for the de facto component lodge.
What are the sections? Married people.
Well, this is the matter lordship.
Oh, acha.
Where lordship, the allegations under section,
This has been inquired. This is for the state. What is the inquiry after 3rd November?
my lord, before that lordship, I want to submit one thing. The petitioner accused is a sub-inspector lordship. My lord, as on date, my lord, nothing, my lord, no effort has been taken from the side of the investigating officer. My lord, the order of the writ petition. Now, my lord, what is, my lord, even then, lordship, is not, even then, my lord, police report is saying that he is not cooperating with documents, they are coming.
Going
My
on.
lord, now, even,
Ignoring my documents,
My
ignoring
lord,
everything, every information I had
my lord,
supplied. Their
when
intention
the,
was to bring me under arrest and place me under
when
suspension.
the police is
This is
saying
this is
that
nothing but
he
they are
is
taking
not
vengeance, nothing
cooperating,
more than
this
that.
is biased investigation.
I
And
will see if
he
you want to live
himself-
with me after this.
He himself.
appeal from the writ order. No appeal
He-
from
he-
the writ order.
My
No,
lord,
we have
he,
considered the read order. They consented to that order. The investigation is
my
required.
lord, he himself is a police, my lordship police.
You are also
officer,
not-
is a sub- my
You have
lord,
been
he
served with the notice.
Police.
You have received the notice,
Repetition.
not repetition. The investigation in for 35(3).
I have not been served with the
She will have notice lordship.
One policeman
He-
saving another.
One policeman is saving another policeman, this is the whole soul, my lord, the thing is going on. Lordships, I have all the documents, my
No,
lord.
no, these are
If-
fake.
That is to be decided at the time of
These are fake photographs. My lord, these are fake photographs.
Injury.
Minor injuries.
Let me see the injuries.
My lord,
My lord,
these are evident. These are
These
all
are the
Photoshop
injuries, lordship. He has taken
things.
11
These are all
lakhs of,
Photoshop things.
my lord, he has taken 11 lakhs of rupees. I have the, my lord, the document of the bank as dowry. My lord, lordship, see,
Your FIR
lordship,
doesn't
see
say
the
so.
injury report of the subdivision
My lord,
hospital,
the
the
FIR is
government
silent about
hospital.
the dowry.
Oh, everything has been come of, my lord, manufactured according to him. Lordship, let this
No,
be, let this
Truth will
be,
come to light one day. Who is
let
manufacturing things?
this, my lord, be
Uncle-
determined at the time of
Uncle
trial,
of
lordship.
the police officer, my lord. He is influencing the entire investigation.
Lordship.
Then why is he not
The uncle
cooperating?
of the defective complaint is a
Then,
police
then
officer,
my
but he
lord,
is
then
doing
my
it.
lord, how this
All the
report-
photographs were taken after putting mercurochrome on the injuries, man.
My
I
lord,
have
the
got the
earlier
information.
investigation, he is not investigating, he is not cooperating. The present investigation, the
That
report
is
is
why
not
she
that
is
he is
not
not
satisfied with the state
cooperating.
prosecution. A separate lawyer had to be given to substantiate the false claim, man. Madam, my humble prayer is that aspect be investigated. Yeah, otherwise I'll be seriously prejudiced.
My lord, he is
I am a
doing his
government law
duty.
holder. There is no
He
question of
is-
running away.
He is.
No flight risk.
What is in the written complaint? Why this May 2025 is a concern in the present proceedings?
My lord, the everything has been started from that incident, my lord. The petitioner has been, my lord, the de facto complainant is my lord, the wife of the petitioner. She has been tortured brutally, my lord, on that night. Now he is taking the plea of alibi. Yes, he went to the my lord duty on 20th May 28 of May 2025. He returned back at night. Thereafter on 27th he went 29th he again went for the duty. So in between the night this thing happened, Lordship. Lordship, kindly see all the documents. These are the documents of the hospital.
Government hospital.
Government hospital. She has lost her eyesight partially. She has lost her.
said that she lost her eyesight.
Partially.
Please. Allow
Just
also.
raising voice will not do, madam.
Boy.
Visas,
ENT
please.
কাছে পাঠানো হয়
Madam, let it be.
স্পেশালিস্টের কাছে পাঠানো হয়
All will be investigated. Let me go through the records. At least allow the court to go through the records.
It's unnecessarily shocking.
My lord, I have learned from my client. From
আজ ডিউটি আছে রাত করতে অনুমানিক টা নাগাদ আমার সামনে ডিউটি থেকে বেরোবেন সিসিটিভি সামনে ask him to cause an inquiry with regard to whether he returned on that day on being deputed to the duty. The allegation in the FIR is 28 May. He was on the duty of Honorable Prime Minister, but in the night he returned. Sir. Now this has to be investigated whether he returned, he tortured on that day, or from 27th onwards he was on the duty and he did not return home. This is to be investigated.
Yes.
Independently, you take out this investigation. Why are you depending on whether he will substantiate or not? It is not his duty. He has filed a document of the government authority of a command certificate that he was, as per the FIR also, he was on duty. But the FIR, there is a change. He came back on 28th May. This has to be investigated whether he was in Alipurduar throughout from 27 to 29. Then the allegations of 28-5 goes. There cannot be. But if he has returned home, then the de facto complainant has a case. Then we have to see what are the injuries and where she was admitted to the hospital and the other things.
Well.
A state files report which is taken on record. Mr. Learned advocate for the petitioner submits that on the date of incident, the petitioner was deputed to the duty of Honorable Prime Minister on his visit on which date? 27th? 29th.
28.
He visited on 28th.
On 27th, I received the command certificate. 27th, I went to Alipurduar.
When was the visit of the Honorable Prime Minister?
It was 29th.
29th.
Police arrangements were made earlier.
29th May 2025.
Incident occurred
The-
20th night.
Therefore, the allegations that the incident took place on 28th May 2025 is unfounded. Learned advocate for de facto complainant on the contrary submits that on the night of 28th May 2025, he returned. He returned to the house and assaulted the complainant.
28th night, Lordship, and he again left the house on 29th morning.
The report filed by the state does not disclose regarding the command certificate which has been annexed to the application. State is directed to file a detailed report with regard to the alibi taken by the petitioner and furnish a report on the return. What is in the case diary after 3rd November? Only sending of notice.
Yes, madam.
Then what additional
Actually, my
thing
lord,
has been done by the new IO?
my lord, from the commandant of the, my lord, can you give me the report?
I have seen the report. You have been sending notice and warning notice.
Warning notice from the commandant.
My
It is
lord,
a departmental procedure, my lord.
My lord.
He is not
He
having duty.
he never went to the,
Okay, you make a detailed
Post,
report of this.
yes, yes.
are the
Because-
officer also not doing anything?
He says that he was not
Warning
there.
notice
but
from the
he-
commandant, my lord.
For absconding.
No, no.
My lord, he is
He is
absconding.
not there.
My lord, if he is not absconding,
Take
then
this matter before the next cabinet circuit.
It was sent to the petitioner, ma'am. Warning notice.
Copy of the application has been given to you. There is a command certificate. The dispute is whether he returned or not. If he returned, then de facto complainant, what he states is correct. If he has not returned, then petitioner has a case. This has to be decided.
That is the question.
He never returned, my lord. This is the report from the warning notice from the commandant that he was not returned to his post, my lord.
He is absconded.
Sure, sure. Next.
my lord, he is absconded of my lord since inception. My lord, if he is my lord doing
Hello,
his
next.
duty-
There is a procedure dictating somebody is pursuing a legal
Wait, wait,
remedy, he
wait.
cannot be said to be an absconder. He is in a process of a legal remedy. Item 30.
ওই পাসওয়ার্ড গুলো দিয়ে দেবো
Sir, এর নামটাও দিতে-
সার্ভিস
Grateful, your lordship.
হ্যাঁ সার্ভিস
Yes, sir. Intimated lordship victim.
পক্সো এই ইয়েস
About 2 years from the complaint. And there is a refusal that court is giving this false complaint.
36.
মেজর then পক্সো ভাই 13 is 791 হিল্লোল সাহা পোদ্দার কুমার সুশোভন পক্সো কেন হলো তাহলে নট পক্সো হোয়াট ইজ দি নেম অফ দি পিটিশনার
চার্জশিটটা দেখো তো
কি করছো
চার্জশিটের মধ্যে পক্ষ দিচ্ছে নাকি দেখে নেবো। চার্জশিটের মধ্যে
এন এই পক্সো আপনি কোথায় পেলেন এই পক্সো অ্যাড করে দিয়েছো কেন কনস্টেবল পক্সো নেই তো ভুল হয়েছে হু ইজ ফর দি স্টেট
I'm from the state.
পক্সো ইজ নট দেয়ার
No.
Not box. I know the proceeding on the 64 to 100. Yes.
did yes what is
Say this.
Another book measure, we have lab relationship, and there are story of about
164
36 page, my lord.
You are for de facto complainant?
No, no, so we are the first step.
Uma. এটাকে এতে রেখে দেবে না এনভেলপের মধ্যে রাখবে
Medical.
Where is the medical? Huh? Medical at
Page 19 to 24.
Starting 2 years.
আসুন inadvertent typographical error has crept into order dated 25th November 2025, mentioning the sections as 64 2M, 64 within bracket 2 within bracket M slash 115 within bracket 2 of the BNS 2023, read with section 812 of POXO Act 2012 instead of section 64 2 within bracket M slash 1152 of the BNS. The sections in the cause title in the aforesaid order be read as be read as পক্সটা বাদ দিয়ে যেটা হবে 64 2M হ্যাঁ কপি পেস্ট ঠিক আছে সার্ভিস রিপোর্ট নেক্সট প্যারা সার্ভিস রিপোর্ট আচ্ছা the order dated 25th 5/11/20 modified to the above extent full stop the other portions of the order shall remain unaltered this order shall form a part of আচ্ছা ওটা দেওয়া দরকার service report filed by the state is taken on record learned advocate for the petitioner service that the victim and the petitioner had previous love affairs and they have entered into physical relationship on consent. Both the petitioner and the victim are major. Top. He seeks for grant of anticipatory bail in favor of the petitioner. Opposing such prayer for bail, learned advocate for the state submits that on the pretext of marriage, the victim was ravished by the petitioner. He seeks for dismissal of the prayer for anticipatory bail. Despite service, none appears on behalf of the de facto complainant victim. Here is the case diary and the materials on record. Para. It is found from the statement of the victim that he had previous relationship with the petitioner and they entered into physical relationship. Subsequent thereto, the petitioner refused to marry. Considering such circumstances, I am inclined to extend the benefit of anticipatory bail in favor of the petitioner. Once in a fortnight, meet the investigating officer, join investigation, cooperate with the investigating officer, attend the court. Attend the court on each date fixed for appearance and hearing. In the event of failure to adhere to the aforesaid যা থাকে ওটা allowed. Five.
Three, my lord. She was pleased to observe that we were taken up by 11:15.
11:15.
11:15, sorry.
Who is for the petitioner? Three te দেখো।
My lord, this is
Item 3.
For one lordship and he got appointed yesterday by Justice Devanshu Goshak. It's a very serious matter, lordship. And lordship, I'm praying for one day accommodation.
It's it was 2 and 3, my lord, it's item number 9. And my learned friend is the advocate on record.
But he's the conducting council, lordship.
Sure. He'll be advocate.
We'll go throughout the day, we'll wait for him.
Lordship, one day accommodation.
One day accommodation is tomorrow.
Yes.
Tomorrow how can I take it up? To the last date of circuit, there are other works to be done.
Learned friend had said item 2 and 3, it's item 9, my lord. So that case is over now.
No, photo number 1, which item is going
2
on?
and 3, they were saying it's showing item 9. So that case is over. Moreover, my
Where
learned
is he
friend
then?
is the advocate on record.
But the conducting council is Sanjay Majumdar, lordship. Advocate Sanjay.
Who will move this application?
Advocate Sanjay Majumdar will be moving that.
Where is he?
Lordship, photo number 1, lordship.
You move this application, otherwise I will dismiss this application. Yes. If you are not interested to join investigation,
There is.
what is this, sir? I have granted you liberty to join the investigation. Now you come up with so many grounds somewhere in Kathmandu, then
He contacted with the investigating officer, Miller, takes some time to join in this investigation. He's seriously ill, Miller.
and the second accused,
Miller, they are husband and wife, Miller.
who is ill? Where is the document?
I have instructed over phone, Miller.
So why the other accused have not joined?
But he's a housewife, Miller. She's a housewife, Miller. She will join, Miller. Both of them. There is a child, Miller, in their custody, Miller.
From Canada, my lord, they will join now.
I need to ascertain this court, Miller, whether they are at present now, whether it's Kathmandu
They
or
learn-
Calcutta, Miller.
So they are
Where is-
abroad. They are abroad.
Where is?
Miller, I need to ask my client.
Either Kathmandu
May I-
either Kathmandu or Canada, my lord. So they are not in the country.
Miller, may I, Miller? At the time of filing, they were Siliguri. Subsequently, after filing this, they went to Kathmandu.
Why?
Yes, Miller.
Why?
After filing this matter, they went to Kathmandu. And when they had a contact with.
They can say.
Miller, they stated me, they were somewhere else, Miller, for their medical purpose, Miller. So they also stated this, to the IO, Miller, so that they were praying for at least 5 days time so that they can come, Miller.
Well,
Certainly, they will come for any, on any condition. Miller.
if they were in Siliguri, my lord, they did not affirm it. They were not here, my lord.
When the affirmation the problem.
We have been repeatedly going to that place, my lord. They are not
They
there.
were escaping.
And
At that
today-
time, they were escaping.
Today, my lord, my
Who is
learned
this
friend-
person then? Brojavasi?
They issued one power of attorney to one Suvan Brojavashi and he filed on their.
Power of attorney, my lord, let it be produced today before your lordship, my lord, will see. Because on the last date, it was my submission that they are not in India. There was no submission on
At that time, they
the,
were Kathmandu, Miller.
and there was no submission, my
And they
lord,
will appear.
from the side of the
Lord,
petitioner saying.
As per
that-
as per the report, my lord, they have said that he had a talk with the client and they just want some time. So
Yes, Miller.
27th, that is today, and 7 to 10 days time, my lord. This is the report, my lord.
And Miller, I contacted with the IO. That's why I also indicated, perhaps indicated that we need 5 to 7 days time, Miller. Just that they
Mahmood-
need time so that we will.
My lord, they will not come.
I will mention the date on which you will be returning to India, wherever you are.
Wait for
You just
it.
take the instruction from your client when you are returning. On such date, it will be placed before the
And
next
where
level
is he
circuit.
right now, my lord.
Get the
They're going to
date,
Canada.
when he is returning. Yes.
I am ascertaining. this.
Yes, ascertain from him when you are coming back. Join the investigation.
My lord,
Yes.
certainly, sir. It will be, no course action be.
No, my lord,
That will decide. If you say that you will come after 1 year, then we'll decide the application.
No.
Then go and get the date.
Okay. Passport. Wait. Until number 5.
এটা কি? Yes.
Finished.
So that is regarding the trades. One and number one and two has borrowed from the ICICI Bank, which is a component bank, and subsequently they came up with an allegation that the seller also involved. I tried to convince the clients and as per the instruction that I get, shall I go to like sequence wise? That will be very much. In the year of 2020, at that time, I get that property, a portion of total 5 decimal of land, from my husband, to an valid gift, that was also under an loan, and which has been completely, cleared, and that, loan clearance certificate also has been given. And thereafter, in 2022, I obtained a loan from the Indian Overseas Bank. I admit in that time, but this is for a construction purpose, and thereafter, they declare me NPA, subsequently, non-performance asset, for non clearing the due debts, and thereafter, in the year of 2024, in the month of September, I get an approach from the accused number 1 and 2. They initiated to purchase my land, and I sold them with a valid sale deed, valid transfer, that deed also along with me, and a portion of 2.5 decimal land has been transferred from my side, and that is for the purpose of, because I said with my bank in the middle of the processing, and as I was overwhelmed in the dues, I plan to sell some portion of my land, that is a 2.5 decimal of land, and by that, try to make the dues are being cleared, by the rest, by that amount. Thereafter,
Where is the copy of the loan agreement with the bank?
with the bank, regarding which bank, the overseas bank. No, that was under the verbal, that was my plan.
Verbal?
Agreement regarding what,
You say that for the sake of construction, you have been advanced a loan from the Indian Overseas Bank.
Sex of construction, I taken a loan, obtained a loan.
Where is the document?
I did not get any document, I tried to,
Lordship, nothing will be,
not get me.
Lordship, sorry to interrupt, Lordship, nothing will be presented before your Lordship, as because he very cunningly, your Lordships, he first he took loan from the Bank of Indian Overseas, and thereafter the processing has been started. And in the meantime, they again sold the said already mortgage property to someone else, and thereafter again he took loan from the another bank. This is ICICI Bank.
I did not take any loan from the ICICI Bank. They have took the loan. My
So
liability don't comes under the who have taken the loan from the ICICI Bank. They have transferred that loan clear that consideration amount to my account. I get that amount, and that that's why I transfer that my portion of the land. So the deed also, and as per the registration,
All the
documents for the original registered deed, they did not record. They are concerned about the whether the stamp duty has been properly served, whether you are present or for the signing or giving the thumb impression or not. Those things are being considered by the registrar of business. I don't come under the allegation which has been completely indulged or arrived by the complaint of the ICICI Bank. This is not part of my concern, generally, if I go with that.
Then what is your concern? You have sold off the property which has.
I am willing to that. I am willing to clear that loan due, but regarding this situation,
But you knowing fully well that the property has been mortgaged to the Indian Overseas, how could you transfer the property?
They have for search, they have made a proper search. To their complaint, it is very much reflecting,
my lord,
Whether the property is encumbered or it is free from all
encumbrances
encumbrances,
whatsoever.
it is knowledge, personal knowledge of the party who is transferring it.
Yes, your Lordship.
The searching by the other side, after being satisfied, will execute a deed of purchase.
Yes.
Now you say that you are layman, a property which is mortgaged with the Indian Overseas Bank. Yesterday you told me that you have no documents. Now you are coming up with the plea that yes, you have taken it. If there is a proceeding, then why did you?
That document which shows.
Ashok,
I have.
let me advocate for the
Look, they have.
petitioner.
Searching law.
Submits that,
That is. written-
My fault cannot take your advantage.
submit that,
The record has been registered in a defective, charging defective session.
That can be rectified at the time of
Submit
trial.
So, but that could be an.
a loan, please. A loan was advanced by Indian Overseas Bank to the petitioner. The petitioner in the meantime has executed a deed of sale of a residential property in favor of the accused number 1 and 2. The petitioner is willing to clear all dues of the Indian Overseas Bank. Yes, case diary?
Lordships.
Any condition will not be relation to the corporate will not investigation. Charge had not been filed yet.
No charge sheet.
After.
Investigation is going on.
Completion of the statutory period will not filing the charge sheet will not after total period of more than 1 year passed will not, no charge sheet has been filed.
No, it's a technical.
Because they have technically.
Yes,
yes. They are part of the mistake in the technicality are very much will not from the very initial day will not. From the registering FIR to filing the charge sheet with the statutory period.
It's a called white collar crime. My lord knows the how you deal. You know the property is not
Aki bolo.
encompasses.
This is for your husband has also taken loan.
Milord, that was clear, Milord. My husband has been taken a loan, Milord, in the year of 2018, Milord, from the Bank of India, Milord.
United Bank.
Sorry, Milord, United Bank. I forget your pardon.
কি বললাম? This is for opposing such prayer for bail under advocate for the state submits that.
Well, that was
There are-
different construction, Milord, a part portion of the bank. Milord.
Submits that the petitioner having the knowledge that the property is mortgaged with the Indian Overseas Bank has
Clearance certificate, Milord.
transferred the. It is a flat.
It's flat.
Flat. Transferred the flat in favor of the other two accused persons. That is the clearance certificate of the husband.
Yes, Milord, from the United Bank.
Trace the case by the materials on record.
They are as a racket, as a part of the racket of this whole illegality, Milord, this shows that there is no illegality, Milord, and they have fraudulently legal
And the
it under the.
Trace the materials on record. The materials on record suggests that the property is mortgaged with the Indian Overseas Bank. Property in question. The petitioner has executed the deed of sale in the meantime when the property was mortgaged with the bank. Considering the aforesaid materials and the nature of the offense rejected.
Obliged your lordship.
Dear. সময় এসছে একটু 9 and 10 টা ডাউন
Item number 9.
দেখো এটা কি হলো, কি ইনফরমেশন দেখি তো, শেষ করে দিন। 9 নেই।
Item number 9.
হ্যাঁ, যেটা 5 ওভার আছে এটা দিয়ে দাও। 5 ওভার 3 3
95 over.
Well, I had a talk with him. He is presently at Kathmandu. By 9th, he will be joining.
9th December.
Without any fail, he will be joining by.
Learned advocate for the
And also
State.
the power of attorney to be produced before the court.
power of attorney has been annexed to this application. Learned advocate for report filed by the Mr. Chakraborty, that later.
Three years.
Later. State files a report furnished by hey Devnath Babu, furnished by the investigating officer Pradhan Nagar PS SPC/SPC dated 27 November 2025. Para. It is found from the aforesaid report that due to health issues, the petitioners could not join investigation. Learned advocate for the petitioner informs the court that the petitioners are presently in Kathmandu. He undertakes that the petitioner will join investigation. They will return, undertake. He informs the court that the petitioners will return to. He informs the court that the petitioners will return to India on 9th December 2025 and thereafter will join and cooperate in investigation in terms of order of this court dated 24th November 2025. In view of the above, list this matter before the next available circuit bench. It is expected that the submissions advanced by learned advocate on behalf of the petitioner will be adhered to. Adhered to.
In the meantime, this no coercive action, he will Kathmandu, how can you go and when he shall come, no coercive action.
In the meantime, there shall not be any coercive action. Yes.
Item 9.
কোথায় গেল 9 10 ইল্লোল চলো পরেরটা দেখো
কি হলো 9টা?
where is Hillol? Hillol Shah Buddha.
That's why you are facing. Let the matter be passed. Actually, of that case, it has been up. We are waiting for him for the last one. Let's go. Item 14.
14. Oh, he has come. Take a 14th din 14. You wait for some time. How many times the matter will be called? Mr. Chakraborty says that he is waiting for you. Wait for some time.
এটা কি 9 আছে?
14. On the prayer of learned advocate, the police station case number. Who is for petitioner in 14?
14. All the co-accused are on bail. The charge sheet has been filed for no
My lord,
investigation is needed.
I could not have in the CD.
But they have already paid before your honor.
You have corrected the case number.
Yes, my lordship.
But I think the corrected brief has not been served with the state office, my lord. This is
Learned advocate for the state seeks accommodation since the case diary has not been produced. Please this matter before the next এটা বেরিয়ে আছে next available circuit bench. হ্যাঁ এবারে দিন তো 9 and 10 টা দিন।
All right.
Service report?
Yes, my lord. Service.
Yes. Sure. What is in the 164 statement?
Yes, my lord. দিন না আমার লেখা ঠিক আছে তোকে বাসবে তোকে করে
An advocate for the petitioner submits that the victim and the petitioner had previous love affairs and the victim left out of her own accord. There are no such allegations of any forcible sexual assault. He seeks for grant of anticipated bail in favor of the petitioner. Opposing such prayer for bail, an advocate for the state, a service report
Yes, my lord.
Service report filed by the state is taken on record. Bold ko rakhbe na envelope. Means that there are specific allegations against this petitioner. of his involvement in the alleged offence. He seeks for dismissal of the prayer for anticipatory bail of the petitioner. Here is the case diary and the materials on record. It is found from the statement of the victim that she was taken to Calcutta on a false representation. And thereafter she was wrongfully confined and forcefully married against her wish and rape. Considering such allegations, rejected.
Great for the Lord.
Next,
Item P9 for the statement.
service.
Service secretary.
Conference, major, from the Indian community, there is a relationship, they are talking phone calls, and there is a proposal of marriage, and if you got a proposal of marriage, they have to lodge this complaint against all family.
Yes, what is 164
Rashid,
statement?
page 4, 164. No, Rashid, page 24 of the 164 of the victim note, page 24.
Medical.
Rashid, medical 15 to 19, page 15 to 19.
পরবর্তী আমাদের মধ্যে সম্পর্ক তৈরি হয়, thereafter events and people went to allow parents and media knowledge there is
Learned advocate for the petitioner submits that the victim and the petitioner had previous love relationship and there are no such full stop there. There are no such allegations of any forcible sexual intercourse. Both the petitioners and the victim are major. He seeks for grant of anticipatory bail in favor of the petitioner. So, learned advocate for the state opposing such prayer for anticipatory bail submits that there are specific allegations against the petitioner of his involvement in the alleged offence. He seeks for dismissal of the bail application, anticipatory bail application. Despite service, none appears on behalf of the de facto complainant victim. There is the case diary and the materials on record. It is found from the statement of the victim recorded under section 164 of the CRPC that there are that the victim and the petitioner had previous love relationship and there was a proposal of marriage. The although there are allegations of assault and there are assault, but there are no such injuries. Considering there are no such notable injuries. Considering the above, I am inclined to extend the benefit of anticipatory bail in favor of the petitioner. Despite service বলেছি? কোনটা? ওটা ডিফেক্ট ছিল? আপনি কেন বললো না? Allowed.
Grateful, Lordship.
Similar submission করে Similar submission. রিজেক্ট হয়েছে? Similar submission.
I can take the victim lordship, I'm for the state lordship. Lordship, victim intimated and victim present lordship.
Well, item 15, I beg to appear on behalf of the petitioner.
Hey, it then this is the intimation.
15, I gather. Yes, my lord. My lord, on the earlier questions, my lord has directed to serve upon the victim. No, the allegation of the opposite party is that he met with the petitioner. They are for the purpose of a loan. Thereafter, a relationship developed, and the relationship ultimately culminated to a physical relationship. The de facto component is a
Yes.
164 statement.
Yes, lordship.
the once the de
Repeated
facto
lordship
component
and
woman
blackmailing the
having-
victim to viral the nude picture of the victim lordship.
No, the allegation is not says so. The allegation is 115 and 69 of the BNS, which corresponds to 323 of the Indian Penal Code, and 69 is the new added sections, which states sexual intercourse by employing deceitful means. The new development has come up with this aspect, whether the FIR has been lodged almost after 1 year. She is a married woman having 2 minor children of 12 and 9 years. She could have understand the consequences. Both of them on different occasions have gone to the various hotels. They culminated a physical relationship. Now, almost after 1 year, it was detected that no, that I have not got a loan for this purpose, so I will lodge this complaint as a vendetta. Kindly see the FIR, my lord, at the initial. Whether the FIR
Interrogation দরকার to seize the mobile phone lordship.
the FIR does not speaks about anything about such thing. New developments are coming up with each and every day. Both are major. There was consensual relationship.
Sir,
My lord.
Mr. Bhattacharya,
My lord.
have you finished?
Please, my lord.
Medical document?
Lordship, relevant page 14 and 15.
Then Advocate Padil, petitioner submits that the victim approached the Bandhan Bank for loan and during such period, she got acquainted with the petitioner. The petitioner, out of her own accord, victim out of her own accord, accompanied the petitioners to different places. Both the petitioner and the victim are major, and the physical relationship has taken place out of consent. He seeks for grant of anticipatory bail in favor of the petitioner. Opposing such prayer for anticipatory bail, and an advocate for the state submits that the petitioner, on the pretext of marriage, has entered into physical relationship with the victim and subsequently refused. He seeks for dismissal of the application for anticipatory bail. Here is the case materials on record. It is found that both the victim and the petitioners are major. The victim got acquainted with the petitioner, who is an employee of Bandhan Bank. And he accompanied the petitioner to Kuch Bihar. And the physical relationship took place between the parties. There are also allegations that the petitioner entered into such physical relationship on the pretext of marriage. Considering the inter circumstances, I am inclined to explain the benefit of anticipatory bail in favor of the petition. Despite service, none appears on behalf of the de facto complainant. বলেছি না? ওইটা আগে দিয়ে দিই। Allowed.
Deeply obliged, ma'am.
Meeting officer once in a fortnight. Attend the court on each and every day, fixed for appearance and hearing.
Obliged, my lord.
Join investigation. Cooperate with the investigating officer.
Obliged, my lord.
Yes, thank you.
Item 16, no, item 16, my humble prayer, can you make it possible? No other matter, I think, acknowledge this prayer, as see some document.
On the prayer, advocate for the petition, list this matter before the next available circuit bench. Yes.
Item 17.
Answer the petitioner, your lordship.
What is it?
Made during the initial investigation when none of the accused persons were arrested. The second was made, but the learned advocate had not appeared, thus why the second application was dismissed by default. Your lordship, with your kind permission, I would like to.
So what is?
Yes.
No. If the accused are not arrested, what is the benefit and what is the demerit of this petition?
Lordship,
Why did you file the application?
all the accused person are granted bail. The principal accused was arrested. He was granted bail by the learned district and session judge Jalpaiguri, and the alleged weapons were also recovered from his custody. And rest of the accused person, they are all on anticipatory bail, your lordship. One of the accused person was granted anticipatory bail by the Honorable High Court.
What are the sections?
Your lordship, the sections are 126 clause 2, 117 clause
No. What is this section? 126(2) is?
corresponding section is 339 clause 2 of IPC.
117 is 326.
Yes, your lordship, 326 clause 2 and 307, 379 and later adding section of 302 was given, your lordship.
He has died.
After some days, he died in the hospital, your lordship. And
Yes.
the accused person are already on anticipated bail.
Yes, sir.
Yes, Lordship, this is the 164 of one of the victims, Lordship, who had sustained injuries. There are total 4 victims who had sustained injury. One of the victims have died, Kajal Roy. And the Kodal, which was
What is his name? Babul.
yes, Lordship. Bablu Roy.
Bablu Roy and
Bablu Roy. Only Bablu Roy has come.
Lordship, charge has already been submitted, your lordship.
Bablu Roy. Who were the applicant along with Bablu Roy in the earlier application?
Your lordship, Andaru Paul was that he has been granted bail already by the district and session judge.
Bail or
After that,
anticipated?
charge sheet, your lordship.
Oh. How many persons have died?
Only one person. Kajal Roy. His PM is at page number 109. He sustained injury, was taken to the hospital, Lordship, in the hospital he died.
PM report?
Yes, Lordship.
PM report?
PM report is at page number 109. Caesar is at page number 208. 109.
109.
109. PM report of Kajal Roy, son of the de facto.
Any other statement of the victim? This is one.
Page 105, one of the injured victim. Page
4
120.
persons sustained injuries.
Yes, 4% sustained injuries.
One person has expired.
Yes, 1% has expired.
Where is the statement of the other 3 victims? Those has been recorded.
Page number 124. Lordship, kindly go to 124. Page 105, Lordship has gone through. 105,
1 and 3.
105, 103, 105, the next
Yes,
page.
yes. Next is
105.
105 I have seen.
Yes, and others are 161, Lordship. It is at page number 124 and 155 of Kajal Ray. 155, kindly go through, Lordship. I think that is the best evidence.
155 is a injury report.
Yes, oh no. My apology, Lordship. Jeevan Ray, relative of victim. Copy of injured. Lordship, page 40 and 42. Lordship, there is the last 164 recorded of one of the victims. It is at page number 97 to 99.
Ashwin. No, advocate, sorry, petitioner renews his prayer for bail. Huh? Anticipatory. The earlier bail application, anticipated bail application being CRM A 277 of 2025 was rejected on 11th April 2025. And CRM A 516 of 2025 was dismissed for default on 18th August 2025. Learned advocate for the petitioner submits that there are no such specific allegations against the petitioner. At the time when the earlier anticipated bail application was pressed into service before the court, the other co-accused were not granted bail. The charge sheet has been submitted.
Charge sheet has been submitted, Lordship.
Upon completion of investigation, charge sheet has been submitted. C seeks for anticipated bail or grant of anticipated favor of the petitioner. Opposing such prayer for anticipated bail, learned advocate for state submits that as per the statement of the witnesses, there are specific allegations against this petitioner of assaulting the victim on the date of incident, resulting in grievous injuries and ultimately death of the victim. He seeks for dismissal of the further there are no change of circumstances since the order of rejection of the earlier order for anticipated bail. Here is the case diary and the materials on record. The statement of the witnesses recorded under section 164 as well as 161 implicates this petitioner of his involvement in assaulting the victim on the date of incident by sharp cutting weapon. The victim sustained grievous injuries and ultimately succumbed to such injuries. The PM report records that the death was due to effects of antemortem injuries, as noted therein. Moreover, considering the statement of the witnesses in the earlier application for anticipatory bail, this court rejected the prayer of the petitioner. In CRM A 277 of 2025. There is no change in circumstances. Consider about dismissed, rejected, and application dismissed. Sorry.
Item 18. My lord, in compliance of your lordship direction, my lord, the victim as well as my lord, the complainant has been, my lord, informed, my lord. My lord, the complainant is, my lord, the medical officer of the, my lord, Shiliguri hospital, and the victim, my lord, presently residing in, my lord, Kishanganj under, my lord, the Bihar state, my lord. Huh? Report no, victim or the complainant. My lord, the medical officer, my lord, the complainant, my lord, he is present, my lord, before your lordship. কাগজ ভাই ওখান থেকে একটু খোঁজ করো এই কাগজ
The notice to the victim has not been served, Mr. Mishra. Notice to the victim has not been effected as yet.
My lord, as my lord, she is residing, my lord, in Kishanganj, my lord, Bihar state, my lord. The concerned police station has been intimated. There was a radiogram, my lord, message, my lord, that has been, my lord.
But this message does not speak that it has been delivered.
Because that was, my lord, the police was unable to trace out, my lord. We have, my lord, done through the, my lord, the concerned PS, whether, my lord, the victim has received it or not.
Did it come up before the next circuit?
Lordship.
A report filed by the service report filed by the state is taken on record. Though the de facto complainant has been served, but service upon the victim has been sent but not effected as yet.
Lord, they got married, my lord.
State is directed to furnish a further report with regard to service upon the victim on the returnable date. Release this matter before the next available circuit bench. De facto, what is his name?
My lord, victim,
De facto complainant?
de facto, my lord, is Ali Hussain. No, sorry, my lord. De facto is my lord, Nilotpal
Doctor, what is his?
Mojumdar, Nilotpal Mojumdar,
Dr. Nilotpal Majumdar.
lordship.
De facto complainant Dr. Nilotpal Majumdar is present in court. Who is he? আপনি কোনো উকিল বাবু রাখবেন আপনার? Please this matter. Next available circuit bench এর appear করবে। আপনার এটা নোট করা হলো।
My lord, his personal appearance may be dispensed.
I have not directed for his personal appearance. I have
All
only
right.
to serve him.
Yes, my lord, only, my lord, there is
Mama,
a, my lord, direction for.
Next circuit bench এ আসবে এটা ম্যাটারটা উঠবে। হ্যাঁ?
বলছি।
Item 19. Yes, yes.
Madam, I'm for the sit. I'm for the statement. Case diary.
কালকে ছিল এটা?
Yes. Yesterday also none
appears,
appeared.
none appears on behalf of the petitioner, nor any accommodation has been sought for. In view of the above, the application, if filing take. This is second application.
Dismissed as withdrawn. Yes, my lord. Not second.
Okay.
Yes, second application.
Is dismissed for non-proceeding.
Item 20.
Why?
I'm for the statement.
On the prayer of learned advocate for the petitioner, raise this matter before the next available circuit.
আপনার যদি অসুবিধা অদিতির সাথে কথা বলবেন বলেছেন আমার দুটো কথা তারপরে
Item 21.
The date, number.
কি আছে
হ্যাঁ, cost title ওগুলো ভালো করে দেখে নেবে।
মধুশ্রী
Appears on behalf of the petitioner, nor any accommodation has been sought for. In view of the above,
দেখিস
the application being CRMA 832 of 20 dismissed for non-prosecution.
নাম দিয়ে হবে সই কথা মানে
22.
Same order. Dismiss for criminal error number টা change করবে। Dismiss for non-prosecution.
I'm for the statement.
Complaint was lodged by the BSF under section 23 surplus to 170 surplus to and 11 of the prevention of cruelty. But alias 379, 411 and cruelty. BSF personnel 6 are cattle lordship in the border at the time of smuggling and in case number 3 lordship. If there is 8, this number 10 lordship, there is specifically mentioned lordship.
reliable learned from our source that the above miscarriage smuggling was done by the following person. From the first source, this petitioner's name was transferred lordship. There is no evidence lordship. Thereafter, some person arrested and found no statement. This petitioner was also transferred lordship.
Who have been arrested? Who is the petitioner? Jalil.
Jalil Mohammed. And other granted bail was thereafter. From his statement also was transferred lordship.
Kalam.
Lordship, all the sections lordship, punishment below 7 years lordship. Till today, no notice was served lordship. Lordship, in the speaker lordship will deny my judgment of our rapid football. That is only one.
He is a member of capital marketing from India to Bangladesh.
Kindly please up to page number 83 lordship. Page number 83, para 73, B lordship. An investigative agency and their officers are bound to comply with the mandate of section 41 and 31A of the code and the direction issued by the court. Any deviation on their part has to be brought up the notice of the hierarchy by the court, followed by the appropriate action. Thereafter, C lordship, kindly C lordship. The court will have to satisfy them on the compliance of section 41 and 41A of the code. Any non-compliance, which is specifically mentioned, any non-compliance would entitle the accused for grant of bail. This case was lead to the no notice was served to the petitioner lordship. Petitioner is ready to cooperate with the investigation.
Yes.
The present petitioner is the one of the member of the cattle smuggling team, and BSF personnel recovered 22 number of Indian cattle.
22.
22.
Okay.
Valued rupees 3,18,000.
Who have been arrested?
The 2% has been arrested.
What there?
On the source, they have been caught, arrested, and from their statement, and also the social, also the source information, this petition name has already been reflected from their statement as well as the.
When is the statement?
Lord,
Of the accused?
yes, my lord.
Involved accused.
18, which 18, 40, 41, 50. And 57 also.
Judiciary agreed the higher court, and if the source identification is not restored, citizens also not very value before the trial purpose.
Page 18.
What is your name? Kalam.
Yes. Co-accused, my lord. Kalam is the present petition.
Accused Jalil.
There is no particular, nothing, money transaction or any eyewitness, nothing. Only the confessional statement which is barred by evidence act and the source information which was because I will be included. Valid kind of. Someone.
An advocate for the petitioner submits that. And independent witnesses?
Lord, no individual. One police person has give their statement. Give his statement under section 161. Millet at page 19 to 20.
An advocate for the petitioner submits that only on the basis of statement of who accused, this petitioner has been implicated in this case. There are no notice served upon the petitioner. He relies on the decision in Satyendra Kumar Antil versus Central Bureau of Investigation and other. What is the citation?
It's notice also this hard project.
What is the citation? Citation.
Yes, I do.
He seeks for grant of anticipatory bail.
2022 lordship, INSC 6690.
देखते हुए की আছে special literally can it 5191 of 2021 1 opposing such prayer for anticipatory bail and an advocate for the state submits that oh the other accused person granted bail.
Chapter arrested and conducted and lordship another accused. Agaman because not arrested. Because not arrested.
Asma? There's no information regarding.
There are specific allegations against the petitioner of his involvement in the smuggling of cattle. On the date of incident, 22 numbers of cattle were recovered. So this cattle was recovered without there being any person arrested.
They gathered with the cattle, but when they chased, they fled away. And after source information, they have been brought.
Here is the case he seeks for dismissal of the bill application. Here is the case when the material is on record. It is it appears that the name of the petitioner has transpired from the statement of the co-accused. Consider the aforesaid. I'm inclined to extend the benefit of anticipatory. Allowed.
Ungrateful human.
15 দিন অন্তর দেখা করবে join investigation, appear before the court on each and every date, and will cooperate with the investigating officer. Don't ওটা ফাইলের মধ্যে রেখে দিয়েছে কারেকশন হ্যাঁ ফেরত দিন এটা লেখা আছে তো
Thank you.
24. Regarding 24 and for the state, just 1 day accommodation, tomorrow. CDS. 1 day.
next circuit tomorrow it will not be
But tomorrow
there are other matters also. Begin on the prayer of learned advocate for the state, list this matter before the next available circuit bench.
25. Right. Charges are under 8C 20 because
Charge sheet submitted. Who is for the state?
Lordship, I just call the,
Pass
just
over.
pass over. 5 minutes.
কত নম্বর ছিল 25 পাস ওভার yes
26.
what are the sections
300 would be. For Malad, and I think section 3 of the W.
you are the husband
No, no. Mother-in-law, mother-in-law. Husband was in last one, very, very large.
Father-in-law, mother-in-law, and brother-in-law. Brother-in-law, it's true.
charge sheet submitted charge sheet has been submitted
No, my lord. Investigation is
see what
going.
is the answer 482 what is the name of the husband
Number one, they were here.
Minarul.
who is Jiarul then
Jiarul is the brother-in-law.
so here is the Samsul is the father
Father-in-law.
I mean father-in-law Jobeda mother-in-law and Jiarul is the brother-in-law
Brother.
okay. Yes
Husband granted. Here the relative mother, also implicated mother, we property the investigating.
Okay.
And one thing, one leave may be granted to family.
what happened
Section 3
Acha. 3-4 not written leave granted
Incident occurred, my lord, within 3 years of marriage. This is the 183 statement of the mother of the victim. There was insatiable dowry demand and torture.
Efficiency of oxygen. Any oxygen not possible.
Any other statement?
Yes, my lord.
Any
Page
other-
76 is the 183 statement of the father, my lord. And
Page 76.
76 is the mother. Mother's 183 statement.
And 75 is the
73 is the father's statement.
father.
Father.
But this starts with Payal Khatun Amar Mein.
Then my
The
lord,
statement is father.
father.
Same.
76 is the statement of the mother.
Postmortem report.
And page 64 is the postmortem report.
Learned advocate for the petitioner submits that the husband has been granted bail by the sessions judge. Stop. There are no such specific allegations against the petitioners who are parents-in-laws and brother-in-law. He seeks for grant of anticipatory bail in favor of the petitioners. Opposing such prayer for anticipatory bail, learned advocate for the state submits that there are allegations against the petitioner of cruelty against upon the victim lady who died within 3 years.
3 years, my lord.
Within 3 years of marriage. Ajab, a topic of holding. On the prayer of learned advocate for the petitioner, leave is granted to correct the cause title of the application by incorporating sections 3 and 4 of Dowry Prohibition Act. She seeks for dismissal of the application for anticipatory bail. Here is the case diary, the materials on record, the statement of the parents of the victim, those allegations against the petitioners. However, the same appears to be general in nature. The victim, as per the PM report, the victim died due to effects of, madam, page number, PM report,
Page 64, my lord. Page 64.
died
Antemortem hanging.
due to effects of antemortem hanging. Considering the above, I'm inclined to extend the benefit of anticipatory bail to the petitioners. One and three shall meet the investigating officer once in a fortnight until further orders. Shall attend the court on each and every date fixed for appearance. Petitioners, petitioners shall cooperate with the investigating officer. Disposed of, allowed.
Grateful, my
ওই
lord.
ওটা চলে যাচ্ছে বল সেটা দিন তো
For the statement. It was filed in, when you did not get prepared, this is not a submission, your lordship, is a case you filed. You did not get, yesterday also it is done in the list from the very.
On the prayer learned advocate for the petition list matter before the next available circuit bench. Not really. Sudhindra. 376. Where is the affidavit of service? Can I advocate for the petitioner? Submits that service has not been affected upon the. You have not made the de facto complainant party. Complainant has not been made a party in this application. What are the sections?
376.
376.
Yes, my lord.
On the prayer of learned advocate for the petitioner's leave is granted to implead the victim, de facto complainant victim. Victim is the de facto complainant. The victim in the.
The husband is the complainant. Husband is the complainant.
Poxo is there. Poxo is there.
376, my lord. The victim was
Victim. Victim. The advocate for the petitioner is directed to serve upon the victim to register speed post with acknowledgement due and file affidavit of service on the returnable date. In the meantime, the state shall cause service যেরকম থাকে আমাদের, and file service return on the returnable date. List this matter before the next available circuit. Cause the service upon the. Who is the conducting advocate? Who is the advocate on record? You are there. You implead victim. Twenty-nine কালকে 19 এর order গুলো. On the prayer learner advocate list this matter before the next available circuit. 29 or 30.
Thirty-one.
31. Yes. NDPS ARMSEC, what is
Then kindly fix it next again.
on the prayer of learned advocate for the state. Is this matter? It is stated prayer, state.
Thirty-two.
yes, my lord.
32.
আমার একটা ছিল।
For the petition.
What are the
Allegation under section 307, main allegation 307. Now, kindly comes to lordship page 6, that is the written complaint. Page 6 of my petition, lordship. Is that
Yeah.
right complaint?
Habibullah. Ehnaj. Come on. Yes, 6.
If lordship goes through the written complaint,
Is going to a friend's place in Pradhan Nagar with my son. Suddenly I saw space 1965, which was driven by Tango. Yes.
lordship, from the written complaint, lordship will certainly appreciate that the heinous the bad nature of the petitioners have been reflected. But Lordship, I humbly submit before Lordship that this is a perfect example that in this materialistic world, how the relationship and bonds of the family are being destroyed. Kindly turns of the page to page 7, and this Khalilullah Sheikh, petition number 1 of the complaint, he was arrested and subsequently granted bail. This is the bail order. Kindly, Lordship, sees 4th paragraph from bottom on perusal of the CD.
Yes.
On perusal of the CD, detailed order has been given. Kindly sees what are the suppression and what are the facts.
Chief daughter of another accused, Ahanaj Patu, sister of an accused. This is civil achievement transfer property with mother, the de facto in favor of the accused. And previously documentation of several civil and parties. Yes.
Now, the next paragraph, on perusal of the case study, may I read along? On perusal of the case study, it appears that the de facto complaint has suppressed that she is the daughter of Habibullah Sheikh and sister of the prime accused MD Khalilullah Sheikh, stepdaughter of another accused Shahjahan Khatun, and sister of another accused Sharma Parveen. That is the petitioners. She suppressed that she is the daughter and brother and sisters. The dispute is civil in nature, involving transfer of property by the mother of the de facto complaint, Lordship, in favor of the accused Khalilullah Sheikh. On perusal of the documents, it appears that there are several civil and criminal litigations pending between the parties. Next, Lordship. Learned advocate for the accused petitioner files server copy of the order dated 31st/11/2025. That is prior to lodgement of this case. Passed by Honorable Justice Sri Hiranmay Bhattacharya of Calcutta High Court Circuit Bench at Jalpaiguri in connection with writ petition number such and such filed by the accused petitioner Muhammad Khalilullah Sheikh and others against the de facto complaint, and the xerox copy of the agreement dated 12/8/2025 made between the father of the accused petitioner and the de facto complaint at Pradhan Nagar PS forcefully by the inspector in charge and the eye of the case. Kindly sees the magnitude of offense. On perusal of the materials of the CD, it appears that there are no ingredients on 109 PNSS, 307 goes. The injury reflect in the injury report, it appears that there is no bleeding injury and they only reflect history of road traffic accident. The accused has been in custody. Now this Khalilullah Lordship is a handicapped and doctor in profession. His own brother, her own brother, the defect complaints. Now, why the case has been lodged, Lordship? Kindly comes to page 10 of my petition. This is the plaint of title suit 251 filed by Shabnam Parveen, that is the de facto complainant, against one is Khalilullah Sheikh, that is accused number 1, not the petitioner here, and Shama Parveen is petitioner number 3 of the petitioner, present petitioner.
Shama Parveen is the mother.
No, petition number 3 is the sister, own sister of the de facto complainant.
No, who is the mother?
Mother is Lordship 2. And one is the
No, it says that there is a dispute that mother is transferring it.
Mother has
de facto
transferred the property in favor of her son.
Tarannum.
No, mother has Tarannum is the mother. Another sister.
No. The sessions judge records that
Okay.
there is a civil dispute, transfer of property of the mother of the de facto in favor of the accused.
Against the accused, in favor of the
So
accused.
who is the mother?
Mother is Lordship petition number 2. No, that's it. Oh, Lordship, that mother has expired. Petition number 2 is the stepmother. Petition number 2 is the stepmother. The original mother of the de facto complaint and the mother of this Khalilullah also and Shaba Parveen also.
Stepdaughter of another accused.
As because the mother, Lordship, this is the gift deed.
Mother who has expired has executed a gift deed in favor of one of the accused, Khalilullah.
One.
Khalilullah.
Son.
Over that transfer, there is a civil dispute.
To this debate complaint, so she created all these things.
She-
And kindly see, Lordship, the writ petition order, which is here. What she does, she takes in confidence the IC Pradhan Nagar. Lordship, this is the order of the writ petition.
Inspector General Pradhan Police report placement post the petition of find an agreement in front.
As because she was not given the property, her brother was given, she chops up all this plan and files this case. And court records, Lordship, no case of 107, that 307 is not, 109, that is, 307 is not there.
Okay. It will give
It's a
you
car accident.
2-1.
Hmm.
2917. Yes.
Lordship, another document, may I submit those? This is the complaint lodged by us against them prior to lodgement of this case.
But this has not been registered.
No, case started. Kindly says the date, Lordship. We have lodged on 6/8 and they have lodged on 10/8. This is the counter case.
Yes.
My lord, kindly sees the WhatsApp conversation of father. He threatened her daughter that he will get her raped, my lord. Kindly sees the WhatsApp conversation.
So, thank you, that. Thank you.
This is Habibullah.
This is Habibullah, my lord. The father of the complainant.
कानून को मैं yes.
And oh, he reply आगे थे पे हम लोग.
Next
Should I-
yes.
And my lord, the injury report,
That page number.
page 69 and 72. Injury is grievous, my lord. Yes.
In simple, as per the bail order.
Grievous. Hearing process.
Post reason. Sub number being.
Injury is grievous, my lord, and page 72. Her left ear hearing loss, my lord. Sensory hearing loss. Page 72. Left ear.
72.
Yes, my lord, page 72. The last point.
Only one injured.
Yes, my lord, the victim.
The child?
Complainant. No, my lord, she pushed her child, my lord.
Yes.
My lord, I appear on behalf of the de facto complainant. My lord, what my lord senior has submitted with regards to the land dispute, that is altogether a different aspect, and with regards to this incident, that is altogether a different aspect. My lord, Khalilullah Sheikh, that is the brother of Habibullah, who happens to be the brother of this complainant. My lord, he obtained regular bail from the Sessions Court. Subsequently, my lord, we have challenged that order that after obtaining bail, he has been sending threats over WhatsApp, my lord. He has been sending threats over WhatsApp as well as the father, my lord. And my lord, the injury, my lord, the injury, my lord, there are photographs where the injury appears to be, my lord, very grievous in nature.
Yes.
My lord, there are photographs of the injury as well, my lord.
Acha. Photographs are also there.
Hence, my lord,
Yes.
this is not a case where the civil dispute has been given a cloak of criminality, my lord. Or just to take over the land or just to grab the land. We have filed this case and just to implicate them and make them stand back against the wall. My lord, that is not the scenario here. Now the scenario is altogether different. My lord. Kindly sees the WhatsApp. My lord, kindly takes into consideration the WhatsApp chats.
Yes.
The FIR comes to be lodged. The father and the brother threatens over WhatsApp. My lord, as soon as the brother is arrested, the father sends these messages. We have also intimated the inspector, the IC Pradhan Nagar, as well as the commissionerate with regards to these WhatsApp chats. My lord, subsequently, my lord, that is part of my cancellation of bail application. My lord, soon after that, my lord, when the son is released on bail, he sends these WhatsApp chats. My lord. Hence, my lord, the question of releasing on anticipatory bail, my lord, doesn't arise.
Okay.
May I give a reply, Lordship? First of all, regarding that WhatsApp chat, Lordship, we all use cell phones and WhatsApp. If Lordship has any number not saved in the
It's not saved, my lord. It's not saved.
is not saved in the Lordship will find after 5 digits there shall be a gap and then next 5 digits. It has to be Lordship in all the cases. But Lordship finds in the WhatsApp chat there is no gap. All those chats are created for the purpose of this case. And we invite before your Lordship to direct any investigation on this end.
No, my lord, that is not the
By
case.
the
Investigation is going on.
The investigation
is going on.
Lord, please, I did not utter any word when you were saying.
Oh, yes.
Lordship, investigation going on by whom? Against whom the writ petition has been filed. That police officer. Lordship sees that after 5 number there is a gap.
Where is that chat?
Yes, my lord. Page 45, my lord. দেখি চ্যাটটা কেমন গ্যাপটা কেমন এই গ্যাপটা দেখাও কেমন
After +91, Lordship will not find any gap.
I fail to understand
Yes.
where does this argument come from?
Yes, because those
At the
documents
time
are
of trial, this
created
point
for
will
the
be
purpose
taken.
of misleading the court.
Not at all, my lord. Not at all.
So CID investigation may be ordered. Lordship,
Maybe ordered, my lord.
Maybe
Maybe ordered, my lord. But the anticipatory. But the application for anticipatory bail may be done.
Number 2.
yes my lord
Investigation by the same police officer against whom the writ petition has been filed. Who in his chamber, the CCTV has been preserved, Lordship. Forcefully, the officer made us to sign in those documents. So that the land is given to the de facto complainant.
But then why you are threatening the de facto complainant?
No, Lordship, this is totally lie. Kindly see, Lordship, the injury report. The state says peculiarly the injury is grievous.
grievous.
The court does not find in the order. I do not find in
it's
the
written in the report itself
So subsequently, in injury report may be prepared.
My lord.
Because the order of the court says no injury.
my lord kindly see page 69 the nature of the injury my lord the doctor has given it's grievous how can it be manufactured my lord page 69 the nature of injury has been written by the doctor it's grievous
How the doctor has given it grievous?
my lord there was a hearing loss her left ear she lost her
In the outpatient, when a patient is brought,
yes my lord
what the doctor is finding? Doctor said bruise, where it is left post auricular region.
yes my
Now
lord
the victim is yet to be taken to the hospital or further, whether he has loss or not.
page
Or, sir,
yes.
madam, in that document itself, where it is written bruise, he says grievous.
but my lord she has
The doctor has not tested whether there is loss of hearing or something of that sort. He finds a bruise in the ear and he says it is grievous. See, it's your document.
But my lord, kindly see page 72.
72, madam, it comes afterwards. When he's taken to the hospital, there is a further investigation of the injury. Then he says that there is a possibility of hearing loss. At the first instance, when the victim is brought to the doctor, he says bruise in the left ear and says grievous.
Doctor has opined, so my lord,
So,
that it was the injury is grievous, my lord.
so that's why the court has held that there is no such bleeding injuries as such. Court does not say that it is grievous or simple. Because the FIR says that she was dashed with a vehicle.
Yes.
So if she is dashed with a vehicle, the impact of the vehicle and the injuries, that was not matching with the injury report, that is only bruise.
But my lord, she
That
has
is important.
sustained injury, ma'am. Photographs
It is
are
up-
also there, my lord, kindly.
It rakun after the recess.
Wait for me.
And also,
Yes.
YOLO.
Yes, madam.
And also he has raised an issue that there has to be a gap between the two 5-digit and a gap and then 5-digit. Is it so?
Check for the
My lord, investigation is going on, my lord. Let the investigation be completed and let it be.
It a
resolved.
cargo. Wait, Mr. Ganguly.
My lord, before lordship rises, my lord, one difficulty, my lord, I'd like to place before your lordship. Lord, item number 141 of your lordship's list. My lord, the difficulty is there is a direction is required, my lord, for calling for the records of the case, my lord, so that the matter can be heard at least before the next circuit bench. My lord, the petitioner is a 72-year-old man. Lord,
Let it be.
Lord, it will not be called.
First half you mentioned the records will be called for. And in subsequent week you can be heard out.
No, my lord, only a direction is required. A 72-year-old person, my lord, needs to go out for treatment. My lord, he is unable to go due to this.
What for?
Due to pendency of this case, my lord. So at least, my lord, it could be heard in the next bench at least, my lord. Otherwise, one circuit will go for calling of the records.
No. What is preventing the party to go for medical?
My lord, there is the next date is in the month of December. My lord, he needs to attend the date also. My lord, he is unable to move on his own. He needs to.
That can
My
be
lord, only
by the
for
trial
the,
court. No.
only for the direction, my lord, to call for the records of the previous
Before the
case.
next circuit, please.
My lord, here I 01, my lord, I am praying for upgradation. Your lordship, this was appearing after 150, my lord. There is no chance that this will be taken up, but the issue is that, my lord, this man is, was sentenced to an NI act,
Next circuit.
just upgradation.
No.
My lord.
No. Tomorrow, no. Only one matter within 245.
That it will be fixed on 26, my lord. It didn't reach.
What can be done?
Or he will have to suffer custody for 15 more days.
I cannot take it up like this. Chalo.
Tomorrow, my lord.
No.
City.
Yes.
The medical document of Government of West Bengal Department of Health and Family, they say that some disturbance in hearing and she was referred to IOPD.
Yes, she was referred.
Eye surgeon.
Yes, my lord. There was an injury, my lord. Kindly see the photograph, page 11. Kindly see, my lord. Page 11. Under eye? Not refresh, but she was very good.
Page 11 photograph. What is it?
Yes, my lord. There was an under eye injury, so my lord, she was referred to the eye specialist, my lord.
But not
No.
any ENT.
My lord, in reply, there's just one small thing I would just like to draw your lordship's attention to. My lord, there is also my lord, point number 5 says attend ENT.
Yes, my lord. Yes, my lord. It's
That is
written
there.
Attend
That is
ENT,
there, my lord.
my lord.
It is not the case
Kindly
that I
see
was not.
Page 71, my lord. Page 71.
So she was not admitted.
Yes, my lord, I completely agree with that. But it is indeed a grievous.
CRPC says the criteria which falls under the Bibasa.
Yes, my lord.
Heat trauma.
My lord, doctor says that she went to the doctor 3 days back. Incident on 7th, she went on 9th.
Yes.
3 days, after 3 days, she went to the doctor.
After 2 days, 7th and 8th.
No,
Ninth,
3 days.
Ninth.
2 days.
When did the
Ninth
operation?
she.
7th or 5th.
No, 7th the incident took place, 9th
Yes,
she
my
went to
lord.
the.
Ninth she went.
Oh. What about that WhatsApp chat?
Regarding the WhatsApp chat, my lord, page 45 is a WhatsApp chat. I'm not sure.
Any other thing?
Regarding the madam,
Regarding WhatsApp chat, we submit lordship, this is manufactured document. And this number does not belong to any of the petitioner.
That.
madam, that is a matter of investigation, my lord, and regard the point raised by learned counsel for the petitioner, madam, regarding the gap in the number, my lord. My lord, if
It belongs to one Raj Sheikh. Truecaller says.
Truecaller says, my lord, Truecaller, anyone can save the number in as Raj, my lord.
My humble submission.
It doesn't have any authentication.
As per the LL offense is the large on bail.
Lord, but he was
The
taken.
other person are female folk and an aged person.
And my lord,
How they can be?
the issue raised by learned counsel, my lord, unsafe WhatsApp numbers display as a continuous string of digits, my lord. I have just sent a hi on WhatsApp to my junior, my lord. My number, neither my number nor my name is saved on this number. My lord, kindly see there is no gap. It is, my lord.
Lordship, she has saved the number. Now if she says I have to open my mouth,
No.
I restrain myself from saying this is a technicality called E.164. It is applicable to entire world. First is +91. This is our India's country code. Then 5 digit is the zone or national area and the last digit is the local number. This is
Milord.
the format followed by enter word. E.164. The scheme is known as the same.
There has to be a gap.
There has to be a.
No, my lord. Hello, kindly
No,
see.
Milord.
I have just sent a message to my junior. There is no gap, my lord.
So
So
that is not the mandate.
is
Milord.
my
That
number-
There is no such thing which
No
is called
such thing,
the-
Milord.
where there is a gap, Milord. There's a difference between the latest Android phones and the
Yes,
and the-
Milord.
and the old Android phones. In the old Android phones, Milord takes if Milord saves a number or Milord doesn't save a number, there is no continuation gap. There's a gap between the country code and the entire number.
Milord-
And Milord, the latest mobile phones, in the latest Android sets, there is a gap. There's a 91 number, the country code. There's a 5-digit number, and then there is a gap, and then there is a 5-digit number. Well, this is how it. This is how it.
No
This is
matter
the
of
entire thing operates.
investigation,
Milord.
whether the mobile was old
It's
or not.
investigation is going on, my lord. Investigation is
Milord,
going on. Let the
Okay.
investigation be completed.
Learned advocate for the petitioners submits that
Lord, may I take your lordship's leave? I have a matter in court number. No.
submits that the de facto complainant and the petitioners are related to each other. There has been long-standing disputes, civil disputes between the parties. On the date of incident, it has been alleged in the written complaint that the de facto complainant victim was intentionally run over by a vehicle driven by accused number 1, Khalilullah. The petitioner number 1 and who was the other person who was boarding?
One was only.
No, in the rear side.
Oh, that side, Habibullah, then Salman Khatun, Shama Parveen was sitting. Her father was sitting on the.
All the petitioners were there in the.
Yes, as per the allegation in their practice.
And petitioners were also in the vehicle. Therefore, no criminality is attributable to the petitioners so far as the present case is concerned. The complainant did not sustain any grievous injuries and she attended the doctor after 3 days of occurrence. The person, namely Khalilullah, who was driving the vehicle, has been enlarged on bail by the learned jurisdictional court. He seeks for grant of anticipatory bail in favor of the petitioners. Learned advocate for the state opposing such prayer for anticipatory bail submits that petition number 1 is the father of the de facto complainant. And he has sent threatening messages to the de facto complainant. Which is not expected from a father. There is threatening to the life of the complainant if the present petitioners are granted anticipatory bail. The civil litigation and the present criminal proceedings are distinct and separate. The victim was detected by the medical doctors to have loss of hearing to a certain extent due to the said act. She seeks for dismissal of the application for grant of anticipatory bail. Learned advocate for the de facto complainant also submits in this similar fashion and he also opposes the prayer for grant of anticipatory bail. Here is the case diary and the materials on record. There cannot be any quarrel that on the date of incident, accused number 1, Halilullah, The name is correct, Khalilullah.
Khalil.
Khalilullah was driving the vehicle by which it is alleged that the complainant was run over. It is not in dispute that the de facto complainant has filed suit for declaring the deed of gift executed in favor of the accused number 1 to be null and void. The accused number 1, who was driving the vehicle on the date of incident, has been granted bail. Considering the aforesaid fact and the complicity of the petitioners, I am inclined to extend the benefit of anticipated bail in favor of the petitioners. Petitioner 1 shall meet the investigating officer once in a fortnight until further orders. 2 and 3 will cooperate with, all the petitioners will cooperate in investigation. Hello.
One me, Baki me. Grateful, my lord.
Governor. Orders it to orders. Orders.
Item number 1.
This, huh? Mayank.
স্টেটে অভিজিৎ কম দরকার সুন্দর হচ্ছে
This matter is appearing under the heading for orders. This revision.
I am for the de facto complaint.
Yes.
I am for the de facto complaint.
This revisional application has been filed seeking for quashing of proceeding being as against the petitioners. Petitioners are the parents-in-law. As against the petitioners being GR case number 3274 of 2023 arising out of, within bracket, arising out of New Jalpaiguri Police Station case number 626 of 2023 dated 24th June 2023 bracket close under sections 498A 323 506 109 of the Indian Penal Code pending before the learned Chief Judicial Magistrate Jalpaiguri. The petitioner contains that the opposite party number 2 was married to accused number 1, married to their son, accused number 1, namely Sri Joy Kumar De, on 18th February 2022. Stops. It is alleged in the written complaint that after few months of marriage, the petitioner number 1, along with accused persons numbers 1 and 4, started mental torture upon opposite party number 2. Which increased day by day. Further, it is alleged that on 2nd January 2023, when the opposite party number 2 returned back to her matrimonial home after visiting her parental home, the accused persons started to abuse her with filthy languages, and the opposite party number 2 was slapped by her husband and was taken back to her parental home. On 18 February 2023, when the opposite party number 2 came back to the matrimonial home, she was insulted by who is accused number 1? Husband. Accused number 1. On 5th June 2023, the opposite party number 2 informed the alleged incident to her parents over phone, and thereafter, when the parents and relatives of the opposite party number 2 came to the matrimonial home, they were insulted. On such allegations, the FIR came to be registered. Upon completion of investigation, the investigating agency filed charge sheet against all the FIR named accused persons, including the petitioners herein. Stop. Charges have been framed. Oh. Only the charge sheet has been submitted. The petitioners, being the parents-in-law, have preferred the present revisional application for quashing the proceedings pending against them. Mr. Ashok Singhal, Ajay Singhal, parable, learned advocate for the petitioners, submits that the allegations against the petitioners, who are parents-in-law, are vague and omnibus. Stop. The allegations are bereft of any specificity. In order to coerce the family of the husband to mete out illegal demands, the criminal proceedings have been initiated at the instance of the opposite party number 2 de facto complainant, one after the other. The tendency of implicating the relatives of the husband in matrimonial disputes has been deprecated by the Honorable Supreme Court time and again in different decisions. Relying on the decision of Honorable Supreme Court in Khashan Kausar, versus State of Bihar, reported in 2022, Volume 6 SCC 599, he submits that the Honorable Supreme Court, after considering the fact that there is blatant misuse of Section 498 IPC observe that the false implication by way of general omnibus allegations made in the course of matrimonial dispute, if left unchecked, would result in misuse of process of law. The ultimate object of justice is to find out the truth and punish the guilty and protect the innocent. An omnibus allegation has no legs to stand in the eye of law. To buttress his contention, he also relies on which is the other decision you have referred to? One is 22, 2019 is one. No, not that. 2009, relies on the decision of this court in Vishwajit Singh Rai and another versus State of West Bengal, another reported in 2019 SCC Online Calcutta 9387. Relying on the decision of Honorable Supreme Court in
RP Cup,
where is that?
para 16.
RP Kapu you have given?
But in this decision, it has been denied.
Oh, in the
para 16.
22 decisions, 2022.
2019.
Oh. कोई वाला decision. Also, relying on the decision of RP Kapoor versus State of Punjab reported in AIR 1960 SC 866, he submits that the principles has been settled by the Honorable Supreme Court that where there is no legal evidence adduced or the evidence adduced clearly or manifestly fails to prove the charge, this is for quashing the proceedings can be quashed against the accused persons. Furthermore, petty quarrels cannot be termed as cruelty under sections 498A of the IPC. It is to be determined / inferred by considering the conduct of the man, weighing the gravity or seriousness of his acts, and to find out as to whether it is likely to drive the woman to commit suicide or not. Just a mere allegation of any torture would not amount to cruelty as defined under section 498A of the IPC. There are no such injury reports collected during the course of investigation in support of the allegations of torture. Stop. In light of his aforesaid submissions, he prays for quashing of the proceedings against the petitioners. Learned advocate, on the contrary, Mr. Luxam, Luxam, learned advocate for the state, submits that upon completion of investigation and on prima facie materials collected during the course of investigation, charge sheet has been submitted against these petitioners. Thus, the petitioners should be relegated to trial, to face trial, relegated to face trial. He seeks for dismissal of this application for quashing. Mr. Sudeep Paul,
Sudeep Pal.
learned
Yes, sir.
advocate for the de facto complainant, submits that no hard and fast rule can be laid down as to what acts or conduct will amount to cruelty in a given case. The petitioner is a poor lady. In deciding whether or not a particular state of affairs amounts to legal cruelty, the court has to consider the social status, the environment, the education, the mental and physical conditions and susceptibilities of the innocent spouse, as also the custom and manners of the parties. Whether acts and conducts complained of constitute cruelty have to be construed in reference to the whole matrimonial relationship. To buttress his contention, he relies on the decision of this court passed in Srimati Krishna Banerjee versus Bhanu Vikas Bandyopadhyay, reported in AIR 2001, Calcutta 154. Which is the other decision you refer? Relying on the decision of Honorable Supreme Court in Sundar Babu and others versus State of Tamil Nadu, reported in 2009, Volume 14, SCC 244. He submits that the inherent power of the High Court under 482 of the CRPC should not be exercised to stifle a legitimate prosecution. The High Court should normally refrain from giving a prima facie decision in a case where the entire facts are incomplete and hazy. More so when the evidence has not been collected and produced before the court. He also seeks for dismissal of the application. Upon hearing the learned advocates for the respective parties, now it is to be examined whether the prayer for quashing of the proceedings against the petitioners can be allowed or not. Para. The petitioners are the parents in laws of the de facto complainant. Where is the FIR?
Page 20 of man.
Page 20.
Or written company.
A written company. কি বললাম?
The petitioner of the paying loss
Hmm.
of the deductible.
Yes. তারপরে in the written complaint, the allegations against the present petitioners are that they physically and mentally they insulted the parents of the petitioner and complainant, parents of the complainant, and also of instigating the other accused persons to inflict torture both physically and mentally upon the complainant. The 161 statements. Supplementary.
I'm handing over the case day, Lordship.
Those are the only statements.
Yes, those are the only relevant statements.
The statement of the witnesses, 4 witnesses. চার্জশিটে কতজন আছে? No, other than the private witnesses are 1, 2, 3, 4, 5 witnesses. 5 private witnesses. 5 persons.
5 persons, Lordship. But in the case diary, there is only 4 witnesses.
The investigating agency during the course of investigation recorded the statements of 4 witnesses.
Since the complainant is Sukanya Chaudhary, Lordship, her witnesses were not re-recorded.
Okay. 4 witnesses, of which 1, 2, 3, of which 3 witnesses are from the same locality from which the complainant belongs. The allegations against the present petitioners are general and omnibus. It is also not in dispute that during the course of investigation, no such injury report has been collected by the investigating agency. In order to further examine the prayer of the petitioners, it would be apposite to reproduce the provisions of section 498A as hereunder. হ্যাঁ, এটা যে কোনো জাজমেন্ট থেকে নিয়ে নেবেন। এটা হচ্ছে মেন হাসান খাস কাউসার, এখানে বলে দিচ্ছি। In which paragraph of that 22 judgment 498A has been reproduced? Which paragraph? No, that 22 judgment, the provisions of 498A has been reproduced.
And that is in the judgment of Supreme Court that I have given in 2009 was it?
আচ্ছা 9 এর পাইবে 9 এর
14 13
হ্যাঁ 14 এ আছে হ্যাঁ
Investigation is in para 20, 40 is the interpretation.
From the aforesaid provision, the cruelty for the purpose of 498A IPC is to be established in the context of 498A IPC, as it may be different from the other statutory provisions. It classifies that an willful conduct of such a nature that it would likely to drive the woman to commit suicide. Needless to mention that no such statement or materials is coming forth in the records of the prosecution. The Honorable Supreme Court in Ka Khansan Kausar alias Sonam Supra as para 17. Seventeen and 18 টা কোট করবেন এখান থেকে। The decision of this court, this is also of quashing? Yes. এটা হচ্ছে প্যারা 15 টু বলবো। বিশ্বজিৎ সিংহ। Para 15 and 16. In the backdrop of the aforesaid position of law, since it is found that the allegations are general and omnibus, it is a fit case to exercise power under 482 of the CRPC. In the aforesaid, in view of the above, the proceedings being GR case number such and such against the petitioners pending before Learned Chief Judicial Magistrate, Siliguri, Jalpaiguri, stands quashed. The revisional application is accordingly allowed. Interim order if any. Next, your না একটা এ আছে না এক্সটেনশন একটা আছে না
45 একটা ছিল সেটা 84 আইটেম নাম্বার 84
আচ্ছা এইটা আগে আছে না মিস্টার বিশ্বাসের এটা
হ্যাঁ আইটেম নাম্বার 84 স্পিড একটা বিষয়
Learned APP Mr. Aditi Shankar Chakraborty is online.
Okay. Yes.
Chakraborty is online, but he is the senior in this matter. I will start if I fail somewhere, senior will be supplementing and guiding you.
Mr. Chakraborty, you can hear, but he has to unmute.
You have to unmute.
Yes. So Mr. Biswas will start.
Yes, my lord. Yes, my lord.
Okay.
Well,
Yes.
This is a state application against the discharge order. This is an NDPS case, my lord. Two accused persons have been discharged in terms of section 250 of the BNSS by the Land Special Court. Now I'm coming to the facts of the case. On 29/4/2025, SI Neeraj Sundash lodged a complaint with the Jorbanglo police station alleging inter alia that while during the Naka checking on NH 110 within the jurisdiction of Jorbanglo PS, he apprehended a scooter along with its rider, my lord. The name of the rider is Prema Shering Lepcha. Prema Shering Lepcha. Further on interrogation, during the interrogation, my lord, the 78 pieces of tramadol capsules were recovered from the glove box of the dicky man, glove box of the scooty man. Thereafter, he was seizure was effected, procedures were followed, my lord. He was brought under arrest and he was produced before the Land Special Court, and the PC for 3 days was allowed. During the PC, he disclosed the name of one Dipu Thapa. Dipu Thapa name, and after with the help of his disclosure statement and other intel, the police team raided Dipu Thapa's hiding place. That is the Hotel New Sikkim at Shevok Bajar within the district of Darjeeling. The raid was conducted at 3 o'clock at night. At 3:25 AM, he was apprehended from New Sikkim Hotel. Thereafter, he was produced before the Land Special Court and he was taken to, PC was granted. During his PC,
No, this is the recovery of 78 pieces of capsules. This is contraband.
Yes. This comes under.
Yes, my lord.
This is tramadol, my lord.
Huh.
This comes under the list of the narcotic substances.
Okay.
Clear.
No.
Thereafter, Dipu Thapa was produced before the landed court and PC was allowed. During his PC, allowed, my lord. Subsequent,
Just give the forwarding report. Where is that? Dipu's forwarding report.
I got CD. Yes, provided.
Yes, continue.
Thereafter, at the time of arrest of the hotel, guest register of the New Sikkim Hotel was it was produced by the occupier of the hotel, and who is in charge of the conduct of the business of the hotel. There is one Pempa Bhutia. He is the accused number 3. Pempa Bhutia. Here is the seizure list, my lord. Kindly come to page 21. Page 21 of my commission.
This is the seizure of hotel register.
Yes.
Gotcha.
This hotel register seizure, the seizure list shows that it was delivered by one Pempa Bhutia. He is the in charge of the hotel at that point of time.
Vikas was apprehended from this hotel.
Yes, Dipu Thapa was apprehended.
Dipu. Yes, my lord, Dipu.
After going through this hotel register, the police authority, the investigating team came to the conclusion that the hotel register did not bear the name of this Dipu Thapa. Although he was arrested, his arrest memo shows that he was arrested from this hotel, and he in his arrest memo, the signature of witness, in the place of signature of witness, the name of Pempa Bhutia is there. I have annexed. Arrest memo of Dipu Thapa at page 25. Kindly see the independent witness at 3:25 AM. Pempa is the independent witness in his memo of arrest. That means Pempa was there, present there in the hotel at 3:25 at night. And moreover, Pempa's domain over the hotel, prima facie proves from the document that from the seizure list that he handed over the document, the hotel register. After that, my lord, Pempa was arrested on the same day, 5/5/2025, at 19:20 hours. He was brought under arrest, my lord. His memo of arrest has already also been annexed here, my lord. Not so relevant, however. My lord. Thereafter, the investigation concluded. Charge sheet was submitted. Charge sheet was submitted. There was against 3 persons, Prema Shering Lepcha, Pempa Bhutia, and this Dipu Thapa. After that.
So excepting 78 capsules, there was no other further recovery.
Other further recovery. The total recovery is 78 pieces of capsule. Now, after the charge sheet was submitted, they preferred an application before this Honorable High Court, and Sempa Bhutia and Dipu Thapa were granted bail by this Honorable Court. Thereafter, my lord, it was fixed for framing of charge, my lord. Meanwhile, they filed an application seeking discharge in terms of section 250 of the BNFS, my lord. Discharge application was filed. Upon hearing, the learned court was pleased to discharge these two accused persons from the case, my lord. Fixing 23rd December 2025 for framing of charge against only this famous sharing lecture from whom the recovery took. Now, after the impugned order is annexure P2, my lord, page 41. 42. Impugned order. Order of discharge, page 42.
Yes.
Now, the 2 points raised by the court. One is the ownership of the scooty has not been proved. There is no investigation carried out to that aspect. Another is the ownership of the hotel. Then if he is not the owner, how will he be implicated in this case? These are the 2 points.
It also says that there is no material collected by investigating agency to substantiate the allegation against accused number 2, barring the statement of accused number 1.
My lord, that is not the case. That is why that has prompted us to protest this. In our city, my lord, there is ample evidence that accused number 2, the vehicle registration number, vehicle registration document at kindly come to page 20, capital A, my lord. The vehicle registration document that shows the owner of the vehicle is Lapka Wang.
Yes.
My lord, Lapka Wangdi is the owner. Who is this Lapka Wangdi? Now come to page 34 of my application, my lord. 33, my lord. 34 is the translation, my lord. 33 is written in Nepali. 34 is the translation, my
lord.
He is the owner of the scooty. Who is this owner, my lord? He is the father-in-law of this Dipu Thapa. What he says, I purchased a scooty in such and such year. I used it for a couple of years. Thereafter, I had undergone a surgery, prostate surgery. I was advised not to ride it. I had given it to my younger son-in-law, that is Dipu Thapa. So, this statement, it is not a statement of the co-accused one. This statement has relevance. The father-in-law, that is the original owner of the scooty, says that I had given it to my son-in-law, and son-in-law had absolute control, according to this statement, absolute control over this scooty. Now kindly come to section 25 of the Act. I have 2 copies of this. Section 20. May I read, ma'am? Punishment for allowing premises, etc., to be used for commission of an offence. whoever being the owner or occupier or having control or use of any house, room, enclosure, space, place, animal, conveyance, knowingly permits it to be used for commission of any other use for commission of any other person of an offence punishable under any provision of this act shall be punishable with imprisonment for that offence. Section 25. Therefore, from the statement of Lapta 1B, it appears that he had handed it over to his son-in-law. Son-in-law had absolute control over it, and he had given it to this Prema Chering Sherpa to use it, and it was used for commission of an offence under the NDPS. Now, knowing, here is a particular word, knowing, that the NDPS Act provides for presumption about the knowledge. Kindly come to section 35, explanation. The explanation attached to section 35.
Yes.
The section culpable mental state includes intention, motive, knowledge of a fact, belief in or reason to believe a fact. The section 35 subsection 1 starts with the expression any prosecution for an offence under this act which requires a culpable mental state. The 25 requires a mental knowledge. That knowledge is presumed here under the explanation. Therefore, if I place this statement of Lapka, recovery of the same scooty from the accused and recovery of the contraband from the scooty. Now this statement, co-accused statement, the court has heavily relied, co-accused statement, there is no other evidence. The co-accused statement gets corroborated. From the recovery of the scooty, recovery of the contraband, and the presumption of law. At this stage, there is a presumption of law. At the stage of framing of charge, court is not expected to embark upon a full-fledged inquiry as to the evidentiary value. The prima facie material has to be given import. When the law provides for a presumption, the presumption was over. This statement was never mentioned in the entire order. This is silly. This statement of Lapta and the ownership of the vehicle document that has not been mentioned in the entire order. That aspect has not been appreciated. Secondly, about Dipu Thapa. Dipu Thapa, there is sufficient evidence to prima facie evidence to frame a charge under section 27 against Pempa Bhutia. What is section 27? 27 capital A. Punishment for financing illicit traffic and harboring of offenders.
But the charge sheet has been submitted on 27A.
Yes, ma'am. Therefore, if the knowledge is again presumed, he lived in the hotel is now from the teaser list, from the memo of arrest, it appears that the hotel, the domain, the control of the hotel is in the hand of Pempa Bhutia. Prima facie. The document shows that. Now the Pempa Bhutia, now there is no mention of the name of the accused who was hiding in the hotel. His arrest memo shows that he was recovered from the hotel, New Sheba Hotel. And now the memo shows the place of arrest is the New Sheba Hotel. Now therefore there is a presumption that this man, Pempa Bhutia, had definite knowledge and information. The presumption is there. Definite information that he has committed the offence and knowing everything he harbored. Therefore, there is prima facie enough material to frame charge against them. This is my humble submission. Kindly admit this revisional application, and I pray for a stay because the next date is the 23rd of December, my lord. And another point I would like to point out, my lord, the assessment of the quantity has been wrongly done. It has wrongly been done. The assessment in an NDPS case, it is mixed up. The NDPS substance may be there is a 10 mg capsule, 10 gram capsule. Only 4 milligram is the contraband found in every tablet, my lord. The entire 10 mg is to be calculated. That type calculation has not been done. That is there in the schedule. the bottom of the schedule, my lord will find. That is not my contention at this stage, my lord. But at this stage, there is a necessity for a stay order. Otherwise, they will proceed with the trial with a single accused, and ultimately, the entire effort of the investigating agency will reduce into doubles. Will be reduced into doubles. I pray for a stay order.
Charge sheet.
Charge sheet, I have an expert.
Charge sheet, page 26 of the
26.
Yes.
26. Page 26, my lord, charge sheet.
Of my petition, I given the charge sheet.
Page 6, my lord.
I have the duplicate CD, I can hand it up to my lord for consideration. This is a serious error, my lord. The court was oblivion about the statutory presumptions and official of
Section 35, my lord, section 25, along with section 2, my lord, of this act, my lord, is clearly, my lord.
Okay. Ask.
But those are cases at motion stage. I've received the wakalat number from my clients. The
You
copy is
appear.
served upon us.
Appear. Wish for this service upon this state. This revisional application is preferred, challenging the order dated 29th October 2025, passed by Learned Special Court, Darjeeling, in connection with Jor Banglo Police Station case number 25 of 2025, dated 29th April 2025. Section 27A has not been mentioned in the clear portion. Section 27A. It is not stated in the application.
I'm very. I have written
Under sections 22B/2529 of the NDPS Act, within bracket corresponding to special case number 7 of 2025. Preferred by the state court. The facts of the case in nutshell is that on 29th April 2025, accused number 1, Pema Sharing Lecture, was apprehended while he was moving on a scooty. And there has been recovery of 78 pieces of blue capsules. Capital blue capsules ta capital blue capsules every capital PYXWIN SPAS weighing 30.3 grams containing contraband drug Tramadol.
Tramadol. 250 is the commercial.
Tramadol. During inquiry and from the statement of the accused number 1, further investigation was held and accused number 2, Deepu Thapa, and accused number 3, Pempa Bhutia, was also arrested. Pimpa was also granted bail.
Yes, my lord, I asked.
Yes,
The
my lord. Yes, my lord.
were granted bail by this honorable court. Okay. At the time of consideration of charge, accused number 2 Deepu Thapa and accused number 3 Pempa Bhutia filed application under section 250 BNSS praying for their discharge from the case. The date in 4th September 2025. Application to যেটা আছেন upon hearing the learned advocates for the respective parties, the learned special judge under the NDPS Act Darjeeling allowed the application of the accused number 2 Deepu Thapa and accused number 3 Pempa Bhutia under section 250 BNSS and discharged accused 2 and 3. And they were discharged. Challenging such order, the state of West Bengal has preferred the present revisional application. Mr. Aniruddha Biswas, Mr. Aditi Shankar Chakraborty, learned additional public prosecutor through virtual mode, along with Mr. Aniruddha Biswas, learned advocate for the state, submits that during the course of investigation, it was found that the scooty that was seized on the date of incident was under the control of accused number 2 Deepu Thapa. Said Deepu Thapa was given shelter in New Sikkim Hotel at Sevok Bazar by accused number 3 Pempa Bhutia. Referring to the statement of, where is that statement? Translated.
43.
Not 43, 43. That father-in-law statement.
Father-in-law statement, 34.
Referring to the statement of the father-in-law of accused number 2 Deepu Thapa, he submits that the scooty under registration number WB77 capital A 8819 was handed over to accused number 2, who is the youngest son-in-law. And since then, he was using the vehicle. As such, there is no such doubt that accused number 2 was in control of the scooty in question. Section 25 of the Narcotics, Drugs and Psychotropic Substances Act 1985 within bracket, in short NDPS, provides that the person who is the owner or occupier or having control of a conveyance knowingly permits it to be used for commission of any offense shall be punishable with punishment provided in that offense. Section 35 of the NDPS Act provides for the presumption of culpable mental state. Further, charge sheet has also been submitted against accused number 3 under 27A for harboring accused number 2. Therefore, prima facie, there is materials to proceed against accused number 2 and 3 in accordance with law. However, none of the said aspects were dealt with by the learned special judge under the NDPS Act. He seeks for stay of the impugned order. They করে দাও, they. Reverting back to the facts of the case, on 29th April 2025, accused number 1 was apprehended along with scooty, and upon further inquiry, there was recovery of 78 pieces of Tramadol capsules. There are statement of the father-in-law of accused number 2, which shows that the scooty was handed over to accused number 2 for using the same. As per the arrest memo, accused number 2 was arrested from New Sikkim Hotel at Sevak Road. And it is signature is there of the accused number 3, and it bears the signature of accused number 3. In view of the provisions under 25, 35 and 27A of the NDPS Act, this court finds that an arguable case has been made out on behalf of the state of petitioner, state of West Bengal. Accordingly, there shall be stay of the impugned order dated such and such passed by for a period of 6 weeks. Further order, petitioner parties are at liberty to pray for modification and serve.
He may be served upon us, and the next circuit is from 15, my lord. Kindly, I am opposing this stay, my lord. Next circuit is from the 15th of December.
So what is it?
My lord, the next date of the in the trial court is on the 23rd of December, whereas the next circuit is from the 15th of December.
Okay. What is the difficulty? It will come up in the next circuit.
They'll serve us the copy.
Yes, definitely.
Yes.
Grateful, my lord. Grateful.
Okay. This is your 5 minutes. Yesterday told me that he will take 5 minutes to complete.
I was little emotional. That's why it took little more time.
Thank you.
Grateful, my lord. Grateful. Grateful.
Yes. এটা আমাদের বই তো। সেট আউট করতে গেলে করে দেবেন 25 35 সেট আউট করে দেখুন।
This is my application. Your lordship heard this matter on Monday. Lord, I could not produce my affidavit of service. Your lordship can remember. Lord, my junior was not there. Lord, the affidavit of service is there. Lord, kindly fix a date.
Who is for the state? State. Tran 3 of 2025. This is an application for extension of interim order. Affidavit of service filed. Hey, Amita Babu. Affidavit of service filed on behalf of the petition is taken on record. This is an application for extension of interim order.
Within time.
Mr. Rajdeep Mojumdar, learned senior advocate appearing for the petitioner, seeks for extension of the interim order. Okay. When was the order passed granted earlier?
Initial order was passed on 3rd of July. Subsequently, it was extended on 1st of September.
Okay. He submits that the application for extension has been filed prior to the expiry of the interim order. In view of the above, the interim order granted earlier on 3rd July 2025 and lastly extended on 1st September 2025 is reinstated and extended for a period of 6 weeks or until further order. Place this matter before the next available circuit bench under the heading contested application.
Yes, deeply applies.
Can 3 of 2025 disposed of. কোনটা লাগবে এবারে? ও
23, 25
কালকে কি নিয়ে নেবো টুই মেনশন ডে? তাই করে দিন তাহলে টুই মেনশন ডে। কত নম্বর আইটেমটা? কালকে একটা টুই মেনশন রেখে তাহলে কারেক্ট করে দেবো। দেখেনি ফাইলটা কেন ভুল হয়েছে ওটা? আজকে আর নেবো না, হবে না, যেটা হবে না। আজকে হবে না। আর কি করবে? এখানেই শেষ করুন, দেখো এটা কি জন্য দাঁড়িয়ে আছে নীলয়? মিস্টার চক্রবর্তী, ইউ হ্যাভ এনি ম্যাটার? 86 ঠিক আছে, ওয়েট 86 কি আছে দেখি। 86 what is this? ও আজকের মোশন করবো না।
My lord, in this matter, there are similar matters in which the 86 item number 86. My lord, there was a mutual understanding and the husband and wife have filed for divorce, and it was the direction of the court to file joint compromise petition. As because the petitioners are out of station, we could not comply with the order. My lord, kindly post it to the next circuit.
So I'm not passing any order, automatically this will go to the next circuit.
Publish, complete.
Your matter. I have to correct all the orders now. I will stop here.
All based on the
Next circuit.
I feel, one of the language in custody, 12 months imprisonment is language in custody for 3 months, more than 3 months already, man. Otherwise, another 50 days, ultimately my revision will be effective.
How? How many days?
Kindly fix it tomorrow, I will not take more than 5 minutes, man.
No, your 5 minutes, I have experienced your 5 minutes. I have experienced your 5 minutes today.
My lord, that is for the state, not for the petitioners.
No, it is.
That is for the
Chalo,
state. My lord, kindly it may be taken up tomorrow. My lord, I will be glad
Mr.
to
Bishop.
my lord.
Next time when I come, I will just allow you to mention and take your matter, not now. There are many matters I have to correct and upload. Not when. What? Please don't mention tomorrow. No, please. Thank you. No, there is no trouble. Mention before the next available circuit. Huh?
Yeah, we'll have to spend 15 more days, we'll have to debate it.
Stay, I cannot help. Thank you.
I will mention it, I know my lord judicial consent will admit it. I know.